Good morning. I'm going to wait a few moments for all of us to connect. All right, I'm going to go ahead and get started. Good morning. It's 9:02 on October 12th, 2023. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. This is phase 3 of the hearing in the court reference proceeding in the case of City of Marina versus RMC Lonestar, Monterey County Superior Court case number 20CV001387. My intent today is to address the admission of exhibits for phase 3 of this hearing and any objection to the admission of those exhibits. So this is sort of a procedural hearing day that we're to close out phase 3 of our hearing. This hearing is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording and the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. As usual, if at any time you're experiencing technical difficulties and need to reach us here at the AHO, please send an email to admin@hrgoffice@waterboards.ca.gov. AHO staff will be monitoring that email inbox. Assisting me today are several staff of the Administrative Hearings Office. We have Nicole Mullen, Kyle Woldridge, and Regina Graziano with the Office of Research Planning and Performance. And later in the morning, we will be joined by Skylar Anderson of my office. I would like to go ahead and take appearances this morning because it's been a while since we've been together and we may have a smaller group here. So I think it'd be helpful to know who's here on behalf of which party. So I'll go ahead and step through that. So I think we will start with Cal-Am Water Company.
Sounds good. Good morning, everybody.
Great.
This is Michael Betts from Allen Mackins. I have the privilege to have David Osias with us as well from Allen Mackins. Robert Donlin is also with us representing Cal-Am, and also representing Cal-Am and from Cal-Am is Kathy Horney.
Thank you. Thank you, Mr. Betts, and good morning to all of you.
Thank you.
I will turn next to Marina Coast Water District.
Thank you. Good morning, Ms. Kinsey. Kyle Brochard will be representing Marina Coast Water District. Also on the line is Chip Wilkins, Christina Berglund, and Ruth Stonemuzian.
Thank you and good morning. And the City of Marina.
Thank you. Good morning. Skip Spalding, representing the City of Marina. And I am joined today by my colleague, Larissa Meisenheimer.
Good morning. Good morning, Mr. Spalding and Ms. Meisenheimer. And do I have anyone from RMC? I think we were previous. Mr. Neudecker, there you are. I was looking and there you are.
Here I am. Good morning, everybody. James Neudecker for RMC Pacific Materials.
Thank you. Good morning, Mr. Neudecker.
Morning.
And is there anyone else on the line? I don't see anyone else on the line, but anyone else on the line who has not been introduced or had a chance to introduce themselves? Wonderful. Good morning. It's a little bit of a smaller crew here today. To get us started, here's my vision. And I appreciate all of your patience today. I think this may take a little time to step through everything. But here's a very general outline of what I thought we might get to on our agenda. First, I thought we could right up front address the question about the request for extension of time to submit the draft reports of referee and closing briefs. And then I wanted to give a non-binding sense of what we're thinking here at the AHO in terms of our schedule. I realize I think all of you may have a status conference with the court and of course for your own planning. I thought we might talk about schedule there to give you a sense of what we foresee for our coming months. Third on my list was to revisit this question about the model files and whether they should be formally admitted within the evidentiary record, or whether they're being housed within the administrative record is sufficient, and just how we want to handle that. I'm not sure. I've thought about it a fair amount, but I don't know that it's a major question. Either way, it's, you know, it's in the administrative record, but I wanted to revisit that and see what we think we should do just as a formal matter to keep things neat and tidy. Next on the list is to move to the admission of exhibits. I believe during the phase 3 of the hearing, I had accepted nearly all of CalAm's exhibits into the evidentiary record, with the exception of some slides. So I want to return to that question. I wanted to ensure there were no additional objections, that I'm on the right track in terms of the status of CalAm's exhibits, and there were no additional objections that I have missed. And then also to just confirm whether or not there were any cross-examination exhibits that came up after we had that discussion. I'm just not sure. I didn't go back through my records. I'm just not sure whether there were any cross-examination exhibits that were not already offered, either being offered into evidence or already admitted into evidence. And then next, I thought we would turn to the city of Marina. I have the outstanding objection from CalAm with respect to the rebuttal testimony of Mr. Tietze. We can address that motion. We can address, I would take a formal offer from the city of Marina of their exhibits into evidence and address any other evidentiary objections that might be raised, and then also address any, if the city of Marina had any cross-examination exhibits. And then essentially the same pattern for Marina Coast Water District. We have the outstanding motion from CalAm, motion to strike phase 2 and phase 3 testimony of Dr. Kincaid. We can address that. And then consider an offer of Marina Coast Water District's exhibits, phase 3 exhibits, into the evidentiary record, address any objections, and ensure that we're not missing any cross-examination exhibits. There may be, that is what is on my list. I realize there may be other procedural issues, so I wanted to put a placeholder at the end for anything else that we should talk about. But I'll look to the room now. Are there other significant things that you think we should we do this in any different order, or are there major areas that I have overlooked for our day today? Okay, so we'll start with item 1, which was just this time to submit the draft reports of referee. I received the request for an extension from October 31st. I think all of you agreed on the extension of October 31st to November 17th. Frankly, I'm not inclined to do that entirely. Here are the 2 options I came up with, because we do need to, we want to get this moving. I would give an extension to November 13th. I mean, that's only 4 days sooner, but it really, I think, would make a difference to our office. Or the other option is we could, I don't know if this makes sense, so I'm going to look to you, but we could split the closing briefs and part 2 of the draft report of referee if we received. I assume it makes more sense to get closing briefs first. So to get those closing briefs on October 31st, and then the part 2 of the draft report of referee on November 17th, as you proposed. I think that's another possibility, but we need to get started that week of November 13th. We are started. We have part 1 of your draft reports of referee, but we want to get working further on all of this information. So I think I'll look to maybe you, Mr. Betts, to comment first. Do you have any comments or preferences about how we set the deadline for these?
And thank you very much for entertaining all of our requests there. There's just so much that has come in, and getting final transcripts. I really believe there's one thing we agree on, that we need more time. So, and the 2 go together hand in hand so much. So it's probably be hard to do one by the 31st and then the second one by the 17th. So with that, my tentative, not having spoken to colleagues, would be we'd take you up on the November 13th to get as much time as we can. I think they're just so interrelated. It'd be hard to parse it out. That's my humble
And-
comments.
Thank you, Mr. Betts. And I think I've sort of had come to that conclusion. And I realized, one of the things that I knew that is by granting more time, we will get a better product. I appreciate that, and I
Sure.
understand that, and in fact, will save us time because we'll get a better product. So I do appreciate it, and I know all of you have been working very hard on all of these things for a while. All right, with that, I'll turn to you, Mr. Brochard. You're off mute. So do you have a comment or a thought on this?
I agree with Mr. Betts. These things are so interrelated, it'd be very difficult to break it up. So my preference would be the extension to November 13th for everything.
All right, great. And then I will turn to either Mr. Spalding or Ms. Meisenheimer. Do you have a different view or a similar view?
We have a similar view. I agree. It would be very difficult to split them up.
Great. Well, then let's set November 13th as the deadline. It will be an additional, it's almost 2 weeks. I will issue a procedural ruling memorializing that extension to November 13th.
And Ms. Kinsey, what
Yes.
time? What time on November 13th?
That's a good question.
I
What do
was
you
gonna
prefer?
request,
Mr. Wilkins, yes, please.
I was gonna make a request that it be the end of the day, like whatever time it is, because you will have them the next morning. That was the hope. Because arbitrary 1 o'clock deadlines are pretty, are not, I wouldn't say arbitrary, but 1 o'clock deadlines are very difficult. They don't really give us a lot of time to do things. And if we're not going to have it to you by 5, if it's 7 o'clock, I wouldn't think it would matter to your office. So I was just hoping as long as we get it filed by midnight, that would work for you.
I'm willing to go with end of day. This is just a comment. I think the 1 o'clock, and this is helpful to know that we may move the entire office to end of the day deadlines. We ended up with this 1 o'clock deadline because of COVID and the difficulties. Sometimes attorneys would, especially with exhibits, you come in and hand deliver items, and it was really difficult at the end of the day. And so then my team had to be sitting in the office all day long. And then with COVID, we weren't there. And so that was how we came up with the 1 o'clock deadline. Now I think it's a little bit of a residual. We have staff in the Cali PA building. We can receive these things that come in. So we may revisit this 1 p.m. deadline just throughout the AHO. It's really, I think, a bit of a holdover from COVID proceedings. So that sounds fine to me. Let's do by midnight, completely end of the day on November 13th. Are there any other comments on that?
Just thank you.
Sure. And thank you. The timeline, this is when I wanted to lay out just a draft timeline that's in our head here at the AHO in terms of developing this report of referee. First of all, we need time, as you can expect, to digest further the materials, to digest what you will submit to us on November 13th. I had raised the possibility of having additional questions for experts. I also realize your experts have been, and all of you have been going at this quite busily for quite some time on short notice. So what I wanted to give you in terms of planning out your life, both personal and professional, is that if we do have additional questions for experts, what we'd like to do is go through all of the materials, really think about it. We're going to be working on writing this report. And if we do have additional questions for experts, that would be no sooner than mid-January. So we're not going to call anyone in before January 15th. And I give you my word on that. So you can plan your holidays, your vacations, your things accordingly. And if we do have questions, what my vision would be is that we would ask you to bring in your experts somewhere between January 15th and the end of January. And within that time period, we could set dates. And I think we may actually want to do it today. We can revisit this question. I'm gonna it may be helpful to set out dates. I don't know that we'll have questions, but it may be helpful for us to select some dates now or to the best of our ability over the next week or two. We can do this in writing so that we have those set out. If we don't need them, we just cancel them, but then you all can make plans accordingly, and we've done that well in advance. according to that schedule, what I see for the AHO is that we would issue what I'm calling an initial draft report. The statute refers to a draft report that the board circulates for comment by the parties. What I'm envisioning, and I'm open for feedback from all of you, what I envision is that it makes sense here for the AHO to issue what I'm calling an initial draft, or we might call it an AHO draft, whatever it is, sort of a pre-draft report, and to allow all of you 30 days to comment on that draft. The subject matter here is so technical and complex. I can only assume that there may be some errors in what we draft. I mean, just it's and by errors, I don't mean differences of opinion. I mean, just, you know, we may just make a mistake because the record is so complicated. And I want to produce a product that is as accurate as possible. And so I think it makes sense to allow for this initial draft and to solicit input and comments on that draft before the AHO and the board circulates this draft report that's contemplated under the statute that then in itself would be subject to an additional 30-day comment period. Now, having this initial draft does introduce, I think, about 4 to 6 weeks more into our timeline. It will take some time to do that, but we may actually gain it back in the sense that we'll be able to address comments sooner. So this was my thinking. It's analogous if you participated in other AHO proceedings. It has been our practice to issue a draft proposed order, and this would be analogous to the draft proposed order, and then the AHO issues a proposed order which is submitted to the board for the board's consideration. So what I'm thinking is that the AHO would issue an initial draft report for comment around March 1st. If we don't have questions for your experts, it's possible we can move that deadline, not deadline, but that target date up. I mean, I will make every effort to work the AHO faster if we can, but I'm trying to also be realistic and set out realistic expectations that an initial draft report would come out March 1st, assuming we have questions for experts in January and then have to digest that information. If you have 30 days for comment and then we have about 2 weeks to incorporate those comments, that would mean that a draft report is circulated to all of the parties around April 15th. I didn't check these dates, whether they're on a weekend or anything like that. This is just a rough estimate. And then after receiving your comments on the draft report, we would need, under statute, 30 days for comment on that draft report. And after receiving your comments, we would need to set up a board meeting date for the board to consider and formally adopt that draft as the board's reported referee to submit to the court. And I think based on this timeline, we would be looking at actually the June 4th board meeting, roughly. So that is a long time from now. And so that's why it was important to sketch this out, because the process of producing and going through these drafts and comments and then having a product to bring to the board and put on the board's agenda does take a long time. But this is what I envision. As I said, if we don't have comments for your experts and we're able to move this up, you know, the AHO will make every effort to produce an initial draft sooner than March 1st. But with the holidays and everything, I wanted to be realistic about our expectations. So with that, maybe I'll just look to the room. Are there any, if you have comments or questions about what I just laid out, please feel free to speak up. And maybe I'll pose to the room, are there any, do any of you have any input about this proposal for the AHO to issue what I'm calling an initial draft report for your comment?
Maybe just to repeat, because there's a difference that you pointed out between differences of opinion or even disagreement with the AHO and errors. And you're looking for errors, is that?
Well, it would be I mean, I think it's also appropriate to raise substantive comments about disagreements. I mean, that would be an opportunity. I mean, it's still, yeah, so both, Mr. Osias, thank you for bringing that up. I think it's also an opportunity for all of the parties to say, dear AHO, dear hearing officer, you got it wrong, and here's why. I think that those are appropriate comments. And then if we if the AHO does not incorporate those comments in which you think it is appropriate and change the order, you could continue to raise those comments with respect to the draft report, and going forward. I think so. It would be both errors and substantive comments and areas of disagreement.
Okay.
Mr. Donlin, please.
Thank you, Ms. Kinsey. I'm sorry I couldn't raise my electronic hand quickly enough. The comment period between the filing of the draft referee's report with the State Water Board, is that a comment period before the board adopts it for the parties only, or for the parties and the public?
Well, by statute, I'm looking at Water Code section 2015, which says within 30 days after the date of the mailing of the draft, that is the draft report of referee, or within such further time as the court may for good cause allow. That's interesting. Okay, so the court has a control over that time period. Any party may file objections to it with the board. So the statute says any party. I will tell you it's board practice to hear from parties and the public. I think we would allow the public to comment. I mean, I think what we would do is we would generally circulate that draft report for publicly for comment, whether it's from the public or from the parties, because it is going to go on the board's agenda, so the public will have a chance to comment. So we might as well, I'm thinking out loud, but we might as well solicit all of those comments at once, and it's preferable to get those in writing in advance. So I think the answer to your question is it would be both public and parties, although the statute explicitly refers to the right of the parties to submit objections to that draft report. Does that respond to the question?
This is Mr. Osias. Sorry, I know we're because we're thinking out loud together. I hope it's okay.
Yes, please.
Multiple of us, but the what I'll call somewhat unique nature of this public, meaning it's not confidential proceeding, and participants, because it's a court asking for the state board's opinion. Court didn't ask for the public's opinion. Court doesn't, frankly, allow the public to opine in court. I'm not suggesting your rules therefore have to change, but I think we would all be concerned should the public start lobbying in opinions at this last minute that are in any way to be considered by the state board. It seems both inconsistent with the nature of the reference and unfair.
So I appreciate those. This is an unusual setup here. And then here's the response I have, at least just thinking out loud, Mr. Osias, is that because what I envision is that this draft report will go to the board for consideration at a public board meeting. Under the rules governing opening meetings, the public has a right to comment on the agenda item. You're right, that doesn't mean they have necessarily a right to submit written comments in advance, but they have a right to appear before the board and comment on the item as a matter of board's agenda. And that's unavoidable, even if we thought it was something to be avoided. So there is that.
I agree. I'm just saying, I don't think the board also would want to set aside other issues. Wouldn't want to say, okay, now it's time for public comment. By the way, we're not going to pay attention. They won't say that.
Right.
But the board is asking, the board is asked to answer the court's questions and has determined through assigning it to this proceeding to allow the parties to present evidence to you, have you summarize that evidence and opine for the board, and then the board will do what it will. But we can easily go off the rails. I just think that's as much to be avoided. Obviously, somebody going up to the microphone and having the allowed time for public comment. And they might say, we really care about this, get it right. They might say, I live there, don't allow it. They might say, I live there, we need it. Okay, I mean, at that point, those are just opinions, but they say, I've got a new study. I'll use an example. Everybody will hopefully recognize I'm kidding a little bit. I've got a new study from Stanford. It's like, great, you didn't get to participate. You didn't participate. You don't get to introduce that study.
And that I think we can agree, and I see all the hands. I think we can agree on that, Mr. Asais, that the evidentiary record, once we close it, it is closed. And that's that. That's true in this proceeding, and then it would be the same in any other AHO proceeding. I wonder too, we also have time to think about this, since I just sketched out a timeline that's about more than 6 months. Because these are challenging questions. I will just comment, in the past, for those of you, some of you may have, I don't think any of you participated. The board has done other court references, but I believe all of those have been adopted by the executive director, so we didn't have this issue of bringing it before the board. However, it's my very strong opinion that this is such a significant matter. It's significant to the public, it's significant to the court, it's significant to all of you, to your clients, that it is appropriate for the board to consider and adopt the final report of referee from the AHO, so that the report that the court receives carries that weight of full board adoption. So I will just tell you, I think this may be a novel issue that the board has not encountered, at least in recent history, as to how to handle this, where you're balancing between public participation and recognizing that this is a court proceeding where there are specific parties, and intervention is something that's governed by the court and court rules. So it's an interesting question, but I will now turn to you, Ms. Meisenheimer. You've been very patient. Please go ahead.
Thank you. I completely understand that this is a long and complex process, and that all of the parties have been in it for quite some time now. But I do think that this is a matter of tremendous public concern. I do think that there are provisions in this water code that allow for members of the public to participate. And it does strike me as being important that they have that opportunity, given that a lot of folks have a stake in what is going to happen here. But on the main question I actually raised my hand about was, we have the June 4th-ish board meeting where this will be considered. And I wanted to ask if there's any process sort of around or after that. And is that something where the board considers it and then they take another 30 to 60 days and then we'll come up with a final determination? Does something happen at the hearing? I just wanted to get a sense of the process from there.
Thank you. My understanding, with the caveat that this, I think, is a somewhat novel process, is that the board would consider adoption of the draft report at a public meeting, whether it's June 4th or sooner or later. The board could then adopt, if the board adopts the report in full in its entirety, or with minor changes that might be made the day of, a change sheet, something like that, then that report would be final, and the board would direct probably the AHO to take the appropriate actions to file. I believe that's the statutory language. The board shall file its report as referee with the clerk of the court and give notice by mail. So that would happen essentially immediately upon adoption by the board. Now, of course, it's possible that the board says, we don't want to adopt this report, this draft report. Based on the comments of the parties, there are changes that need to be made. And in that case, I suspect what the board might do, if that's their inclination, would be to direct the AHO to draft changes to the report and then bring it back to them. So there could be a follow-up board meeting where the board would then consider a revised draft. Whether or not that would trigger an additional 30 days, that's something we would have to talk about. I'm sure it would depend on whether, not I'm sure, but I suspect it would depend on whether the changes are significant and material to the order itself. So that's another possibility. But if the board were to act on that order in the meeting in the way that the board typically does on other types of actions that are brought before it by staff, then I think that would essentially be immediately filed with the court. Does that, Ms. Meisenheimer, does that at least answer some of your questions? That's my vision. We're all working on this together. Okay.
Yes, it does. Thank you.
Thank you. Mr. Wilkins, I see your hand.
So we had an extensive colloquy with the court at the last status conference about the timing for this report. And
Yes.
I know CalAm's counsel said that the water board could shorten the schedule and potentially have something in November next month. Looking at this, I just am hoping that we can report to the judge that it's the AHO's estimate that a report will be issued in June, or do you think it is safer for us to tell the court something different? Because I don't want us to argue about what your statements here mean. Should we be telling the court June is a likely scenario, but it could be later, or do you have something else you think we should tell the court at that status conference?
I think it would be appropriate to report to the court that we think it's likely that a reported referee will be filed with the court in June or before. But if there are unanticipated extensive comments and changes that would be made to drafts, depending on the draft report, that could take additional time. But I think it's fair to indicate to the court that June is the anticipated timeframe for a final report to be filed with the court.
Thank you.
Thank you. I know it's helpful to have, that's why I wanted to talk about this, because you need to have something to say. Are there any other, so I guess we didn't resolve this issue about the public comment and that kind of thing. What I'm inclined to do is to let it sit with us for some time. And we can return to it. I also wanted to take a look at and think about the process and how that might go. I mean, what I'm thinking is that it may, to the extent we solicit public comment, we would certainly want to be clear in the record, in the administrative record, which comments are from parties and which comments or written statements come in from the public who are not parties to the proceeding. And we would be very clear about distinguishing those, which is one way to handle it. But whether or not we exactly how, I think part of the question is exactly how the AHO publicizes and invites comments on the draft report. That's one question, and I'd like to just approach that once we get closer to the actual time for that. But at least with respect to the initial draft report, the one we'd be creating, or a courtesy draft, if you will, from the AHO, my intent would be to circulate that to the parties to this proceeding, those of you who are here today, and just solicit comments from the parties on that initial draft report. Is there anything else we should talk about on that you can think of now? We can always come back to process, but that we should address now on the timeline or foreseeable process. All right, next on my list were the model files. We had talked during phase 3, during the hearing, about whether or not the model files that the parties exchanged and that were submitted to the AHO should be formally accepted into the evidentiary record, or whether it's appropriate to leave them in the administrative record. They're certainly, to the extent the AHO has them, they're in the administrative record. I think I explained at that time my understanding of the difference between the evidentiary record and the administrative record. The administrative record is the larger category of documents, exhibits, everything that comes into the AHO related to this proceeding. We maintain it. That's the administrative record. Every email, every model file, it's there. We have it saved. It's part of the administrative record. And then the evidentiary record is a subset of that, which are the exhibits. on which the AHO and then in turn the board may base factual findings and other conclusions in the report of referee. I have been thinking about it and talked with my team about whether or not the model files themselves, and by model files, I mean the actual, lack of a better term, the actual computer coding. I mean, the algorithm, the thing that does the work. You have the input and the output, but the black box, right? Which may not be so black, but the actual computer coding. My understanding is that these model files that the AHO received also included input, information about input into the model, and then in some cases runs of the model. So that would be output from the model. And then, as I mentioned, the computer coding itself. So I mean all of those as model files, and we can talk about whether some or all of that should go into the evidentiary record. After a lot of that, at first I thought, well, let's just put it all in, what's the harm? My team pointed out that these model files, not just the code, but the model files themselves, I mean, they're large. There's a lot. There are a lot of model runs that didn't actually maybe do anything. They're not cited by anyone, or they're not, they didn't end up being significant in this proceeding or particularly useful. And so it sounds to me like there's a lot of noise there. So that was one factor. Another factor that I considered is that I don't think it's typical for the model coding itself to be accepted into evidentiary record. Usually you have, at least in my experience, you have the technical reports based on the input and the output that describe the input and the output of the model runs and really break down what happened, but that the models itself don't normally go into the evidentiary record. In some cases, you have models that are actually proprietary, so they wouldn't go into, I mean, we have other issues. I don't think we have that here. But I don't think the models themselves normally go into the evidentiary record. It's not the type of thing the court would look inside the model. You rely on the experts to deconstruct that and look into the model and tell you if there are matters of concern or what it means or how it works. So after considering both of those things, my sense was to make the cutoff at where we have it, which is that these technical reports and the experts' testimony are in the evidentiary record, but the model and the model files themselves are not. They're in the administrative record. We all know they're there. We can access them. We can get to them. But we're going to, when the AHO and the board compiles its report of referee, we're going to have probably a hard drive of the administrative record that we submit to the court and say, here's all the stuff that goes along with this. But it wouldn't be in the evidentiary record. We wouldn't have this problem of trying to bait stamp a model file, that kind of thing. We wouldn't have that noise. So that's my general impression and where I'm coming from now. I'm inclined that my sense is we shouldn't accept all of the model files into the evidentiary record. But if, this is sort of novel territory for me. I don't know if you have a difference of opinion. So I was just going to go around the room and see whether you have a suggestion or a strong opinion about how we should handle this, or any opinion about how we should handle this. Mr. Osias, you're off mute, so I'm inclined to turn to you first. That's what happens. I don't know if that was intentional.
Well, it's fine.
Thank you.
I do have a strong opinion, actually.
Okay, good.
And I've modified it instantaneously after listening to you. But I want to use two hypothetical examples that illustrate what I suggest before I give you even the suggestion. And that is, an expert goes into the model files using your broader definition, and by looking at it is able to include in a draft referee report or closing brief, or both, examples of selective consideration of available data, or exclusion of selective data. And if wanted to use that portion of a model file to make that point, should not be unable to do so because it's, quote, not in the evidentiary record. Okay. So that would be one example. Another one, perhaps less likely, but possible, is that by looking into a model file, an expert could opine that the things that most of us on this, or maybe all of us on this Zoom are less familiar with, but the algorithm or the coding or the prepackaged software has itself been modified in a way that makes a result more probable or less probable. And if there has been a software, I'll call it, that probably not the right word, alteration that an expert thinks illustrates something relevant, that shouldn't be prohibited because it's, quote, not in the record. So when I was thinking about those examples, I was going to conclude, therefore, it should be in. But you're right. I'm going to guess that that's going to be a small subset of a massive file. And so perhaps it's only admitted into the record if used, and the rest just stays in the admin record. But it shouldn't be grounds for not considering those either arguments or evidentiary examples because the model files are not in. That would be the wrong conclusion, I think, in light of the proceeding.
Thank you, Mr. Osias. I think I agree with you. I want to ask some clarifying questions to make sure I understand the examples, which are helpful. Because I also was going through this exercise of trying to imagine a scenario where it would be a problem that, some of these model files are not formally in the evidentiary record. So I want to clarify in these examples, the expert opinion with respect to the changes in the software or certain inputs and outputs, that kind of thing, this testimony. Because here we are at the end of phase 3 of the proceeding, all of that should already have been offered, or we're going to consider today, offered into evidence. And so as long as it's accepted, once accepted into evidence, it's in. There would be no future. Would we have an additional need at that point for the model files to be in the evidentiary record? Because then we have this testimony with respect to the model files. It's in the evidentiary record. Do we then have to drill down further? I mean, is there any scenario where you have to drill down further and
I wasn't, well, so, and perhaps I'm, by being brief, I'm being less clear than helpful. A lot of modeling is forms of automated calculations on tables of data. Okay. And you can actually go into a model file, I believe, and extract the table of data. Okay. Let's assume someone did that, attached it to their argument in closing and saying, look at this table of data pulled from, very explicitly labeled where and what model. And I'll use a silly example only for illustration. And you can see that no weekend data was ever considered. Okay, because let's just assume the table has days of the week. Right, so it's not, it's apparent, right? If that's in the model files, that's not new evidence if the model file's in evidence. It might be true that that table of data did not find its way into a summary slide or a TM because, as you know and have even observed, there were time constraints for both hearing prep, hearing proceedings, summary slide length. And so not everything that might be said has been said, but it has to be the rule that everything that might be admitted into evidence has to have been admitted, right? So what I'm trying to suggest is if the model files are in, then there isn't an argument about what's been admitted. That's all. I'm trying to eliminate that argument if something in a model file helps prove a point. Okay. I don't know if that's helpful or not.
It is helpful. Well, I think, yes, I think it
For
clarifies.
clarity, anyway.
So let me,
Yeah.
and now my brain is working, but I would think Ms. Meisenheimer, I believe your hand went up first, so I will turn to you and then Mr. Brochard. I would love to hear from you.
Yeah, thank you. I think it's a complicated issue. From my perspective, the key question is, what is the difference in terms of how we can use these files, right? If it is admitted versus in the administrative record. And I have not gone back and looked at the rules to sort of scour it and see the difference. But I think it would be helpful to clarify, if it's in evidence, we can use it in this way. If it's only in the administrative record, here are the limitations. If somebody sees that there are limitations, because I think that will guide which bucket they need to go into. And then the second thing is that unlike our evidence, these model files are not necessarily static always, right? We have put model files in each of our folders. And so, for example, in the Marina folder, we have model files, every party does. But presumably, the AHO experts are going to be looking at these and maybe sort of modifying, extracting, running, doing different things. And so we may also need sort of another folder for what the AHO is doing or developing. And the other experts on this line may be able to speak to that more than I can. But it strikes me, understanding the distinction between the two and then understanding what happens if anything's modified are the two questions that I have.
Thank you. I don't know if I have answered. In terms of the difference between the administrative record and the evidentiary record, I think, one way to illustrate that, and there are no rules. I don't think that these terms administrative record or evidentiary record are used in the regulations, not explicitly. I don't think they're in the statute. This is a matter of AHO practice. I aspire someday to have rules for the AHO, but I need a larger team to do that. That's a bigger picture. But for example, exhibits that are offered into evidence and then are excluded, they're not admitted into evidence. They're in the administrative record, right? But you can't cite to them as a matter of evidence and as a basis for factual findings. So I think the difference here is that if the model files are not admitted into evidence, then the model files by themselves cannot be relied upon to make a factual finding or to support a factual finding. That's not to say that a technical report that is admitted into evidence that discusses the model, what there are these technical, as I understand it, the technical reports talk about the inputs, how the model was run, and then the outputs. And the expert testifies, I conducted these model runs, here's the output, here are the results that lead me to the following opinions and conclusions. All of that can be relied upon. It's not undermined just because we don't have the equations or the coding of the model itself in the record. We have the input and the output. At least that's my understanding, that's my vision of this, with the caveat that this is a complicated issue. I guess one way I thought about it is that if you have a doctor testifying about, as an expert about reading X-ray results, you don't have the X-ray machine in evidence, right, as an exhibit. You have the doctor's testimony about what was done, how the X-ray was taken, what the film shows, but you don't have the actual machine in evidence. That may or may not be an appropriate comparison, but that was my.
Well, you might want the machine in evidence if
That is true. If you have
if
concerns.
the lawsuit is about the spot showing
Right.
up on the lung and it turns out to be dust on the lens.
That is correct. You yes, Mr. Osai, but typically the machine does not go over it. That's so maybe that is exactly the crux of the issue here.
Yes,
Mr. Brochard, I think Mr. Brochard, you had your hand up. I don't know. I want to give you a chance to jump in, and then Mr. Osai, I'll turn back to you.
We've been at this for well over a year. There have been multiple models and many model files. None of them were submitted into evidence as exhibits, I think, until this last round where CalAm tried to labeled some of its model files as exhibits. I don't know that we had any testimony specifically about those. I know they weren't put up on the screen during any of the testimony, and I don't think that the model files should now be exhibits. And I don't know if they were going to be, how would we handle all of the prior versions and all of the prior model files? I think it just creates a lot more confusion. I think you're correct that you don't put the X-ray machine in evidence. I mean, you can bring it in and show it to the jury if that's what you're doing, but we're past that, I thought. So the exhibits should be the written reports and the written testimony and the figures and the tables that everyone has provided. And when we do our closing briefs and we do our version of the draft report for you, I think we should be citing to those documents and that evidence. And then, of course, you know, the AHO has their own experts. And if the AHO wants to open up some of the model files and say, we've opened up and done an independent investigation and we believe this stuff has happened, or this is what should happen, I don't know that there's anything to stop you from doing that. But Mr. Osias's comments really raised a concern to me that these closing briefs are going to turn into attorneys in a brief trying to tell you what tables in a model file that have not been testified to are supposed to mean and how they should be interpreted. And I don't think that that's appropriate at all.
Thank you, Mr. Burchard. I think Mr. Osias, I'll turn to you, and then Mr. Wilkins, I saw you had a hand there too. So I'll turn to you first though, Mr. Osias.
Well, I just soon hear everybody who wants to argue against me.
That's
and then
fine.
go-
I didn't want to argue.
That's all right.
Mr. Wilkins, do you have something to add?
I think Mr. Burchard hit what I was going to say. I was very concerned with Mr. Osias's comment that we would put in our closing brief additional arguments about the model files or what was done by the experts that no expert has testified to as to date and no expert has had the ability to respond to, given the large number of files that could potentially be used. It seems like another round of rebuttal potentially. And so I was very concerned about that scenario because I believe Mr. Lilly told us that once we were here, there would be no further testimony. And now we would be going back and asking our experts to potentially go through the model files and see what problems they could find. And we have not endeavored to do so, and I don't think we want to at this point.
Thank you. Mr. Osias.
A couple points. I hope I don't forget any of them. First, at the beginning of this proceeding, the observations plural, because it's occurred over multiple times by Mr. Lilly, in many ways echo yours with respect to the size or scale, of model files. They're big. They could not even have been uploaded. So they were special procedures for delivering them to each other and to the AHO were needed. Okay. Second, it was, and I believe remains, a part of this proceeding that the model files be delivered to each other and to the AHO, but I'm going to focus now on the AHO part, so that the AHO could run the models, could independently evaluate the models. I believe that is still an important opportunity, which I don't know whether we will invite you to do so with some map. I'll use that non-technical term to what specific portion we would want you to go ahead and do and see how it skews results, but it's certainly possible. And that's why you have model files rather than just reports. And we also might say, they testified that they took all this into account. And if you open the model file, you'll see it's not in there. I'm obviously creating examples for illustration because I don't think it's possible to really discuss this without giving you some things, but I'm not saying any of that will happen or but it shouldn't be precluded for is the model file in evidence or not basis. Now, Mr. Brochard and Mr. Wilkins are worried that somehow there's new opinion in the guise of Mr. Osias's writing or something. I mean, that's an objection all by itself, independent of whether the model files are in evidence, right? What I think is unfair is to say, well, you can't point out something about the model file because the model file is not in evidence. And you haven't pointed it out yet. We weren't required to in a proceeding that was new. I don't know how many times it was called to be a summary of your evidence, a summary of your testimony. I mean, at one point we were given, 15 minutes to summarize direct testimony. So this goes a little bit to what Ms. Meisenheimer said. Can you use it? Can we cite to it? Okay. I think the answer should be yes. I was suggesting, but if nobody cites to any portion of something and you want to make the evidentiary record smaller, I didn't have an objection to that because you called it noise, and at that point it probably is. But important portions of model files in the expansive way you described them should not be off the table in terms of go to a closing brief example. What do you do in a closing brief? I was told you summarize or point to the evidence that you think supports the legal conclusions that you're asking the hearing officer to make. If one of those pieces of evidence is on page 1918 of a specific model, so that Mr. Brochard knows which one we're looking at, that shouldn't be objection. That page is not in evidence, right? That's my point, and nothing more than that. And I think they weren't originally put into evidence because of size. They're on hard drives that we delivered, I think. So this is much more a use of them issue, I think, than I mean. But it turns on a little bit what you're going to end up concluding on this question of where they are in the record. But I'm focused on how they can be used.
Thank you, Mr. Osias. I'm digesting this. I understand your arguments, but just because we're brainstorming here, I'm thinking out loud. I mean, with this, I don't know, this X-ray example may not be a good one, but I do have some concern that you're foreshadowing what does sound to me like additional expert testimony that's going to show up in a closing brief. And the reason I'm thinking, for example, I, as an attorney, if you give me an X-ray machine, there may be dust on the lens, but if I go in there and say, look, there's dust on the lens, I don't think I'm qualified to write in a closing brief. I looked at it and there was dust on the, I mean, it's a complicated enough piece of equipment that I don't know that I could identify dust on the lens versus something that's supposed to be there, but you need an expert to interpret it and to tell you this is how the machine is supposed to work. I don't know that, I don't know what your technical background is, Mr. Osias, but I suspect you can't go into the model without the help of the experts and say, look, this table is incorrect. Right, you're going to need an expert to interpret that, and then shouldn't that expert testimony already be at least offered into evidence at this point in the proceeding? Or are you making a point different than what I'm getting to?
No, well,
Okay.
I guess yes and no, right?
Okay.
Because proceeding did not permit lengthy. I'm not saying it wasn't a long proceeding, but there was a lot of abbreviated time to walk through things. There's also, okay, certainly in the live proceedings, let's start with that. Okay, less so in the written, right? So the difference between what's in the file and an opinion about it is, I think, important. The model files, and by the way, let me back up and start with your foreshadowing comment. I only wish I was far enough along to be foreshadowing something I was going to do. Okay.
Fair enough.
I mean, I'm being as sincere as I can be. There's been opinions, without going into the merits of any of them, by both sides about what someone didn't do or did do but shouldn't have done related to modelings. Okay, so set all that aside. I'm talking about what's in the model files. If someone went and opened it up and found the page, okay, and can you cite to that? Let's just start with that, okay? Because I'm not asking you to say, if you can cite to it, you therefore can submit new opinion. I mean, you know, I think the answer is no. I think people are arguing that this is some excuse to submit new opinion. I think your question about the X-ray machine suggests, is it possible to cite to something in the machine without having new opinion? Okay. If it's new opinion, you get to be the judge of that, frankly, right? So you're in a good spot. Then you can not consider it. But if it's, you know, not new opinion, this is the machine. It's not plugged in or whatever. I'm trying to think of an objective thing that you don't have to have an opinion on. It may not prove anything, or it may prove something, but it should be citable. I mean, this is just what it is proper to point to, in my opinion. That's what the evidence is. Okay. And you know, lawyers are many times aggressive and overreaching. I am not asking for no opinion, but I am asking for, it's okay to point to something that's there, and you can confirm it's there. And it's not, well, he didn't write about it already. That would be the written documents. He didn't write about it already, so you can't have him open up the model file and look at that page to see if Saturdays are missing. Okay.
I would say that's exactly what you cannot do.
I think
The model files are not PDFs for they're not PDFs. That's something you open in Adobe and you can take a screenshot. That's not, and if you could, then that should be an exhibit that you're citing to. And if you haven't done it, then it's not an exhibit. These are not self-explanatory things. That's why we've all spent an unbelievable amount of money on experts to appear to tell us what they mean. To have an attorney try and create a table that doesn't exist from a model that hasn't been testified about, and then put it in a brief and say, as an attorney, this is what it means, even though no expert, I can't cite to any of the testimony an expert has provided to say what this means or doesn't mean, is completely inappropriate.
If I could just, I understand what Mr. Asias wants to do, and I understand the desire to sort of go back and comb through the model files and identify more issues. But here's my concern, and that is we have been doing this for a very long time. It has been round after round, and each of those rounds have been very, very carefully structured so that there was an opportunity for, you know, us to put in model files, CalAm to identify issues in the rebuttal. And there was a hearing where everyone got to talk about it. So there's been an opportunity to go through everything that's been submitted. and provide those critiques and rebuttals. And there were no page limits on the rebuttal testimony, right? So it was sort of a full ability. If we were to now permit parties to go back to the original model files and start identifying new issues, which I do believe would require expert input, and then raising those which haven't been raised before in these closing briefs, we're going to trigger another round of a situation where whoever's raising these new issues, the other side should get an opportunity to respond. There may be experts who need to come in and talk. It's in essence risks opening up another round of this hearing to allow people to sort of go rogue and bring up new critiques through their experts based on modeling files now.
Thank you. Mr. Osias, I'll give you, if you would like, one more opportunity, and then I think I'm going to.
Yeah,
Make
I mean, I think you understand the difference, but I keep getting opposition based on how it's going to be used, not whether it can be used. I'm not asking for the how it can be used. I couldn't disagree more with what Mr. Brochard said. Everything in a model file is not a simple table that you could actually point to a page, but some things are. We actually had one come in, and it was a screenshot of a piece of a model file. It happened to be testified to, right? But it was a screenshot, and that should be, if it hadn't been done already, there's no reason it's not admissible. All the evidentiary objections about new opinions or whatever is something not about admissibility. And although Ms. Meisenheimer is entirely correct on the page limits, she would also, I think, admit that although there weren't page limits, there were days limits. Things were due over a certain calendar period, which tended to cause people to do as much as they could in a hurry, which isn't necessarily everything. So there was no advance determination that something in a model file couldn't be pointed to because it, quote, wasn't going to be admitted. And second, it'd be hard to reconcile that rule with the AHO running model files. I mean, that was the opportunity that we were told to give you. And we will encourage you to do it. I'm pretty sure that'll show up somewhere in our brief. Run the model file. Look inside it. I mean, why else would you have it? So that if you, given what you laid out, maybe I'll try to wed two things together. If you relied on something that someone thinks is new opinion, that'll come out in a comment. But if you rely on something that's just there were only even numbers in this entire model. Our staff had a problem with that. Couldn't understand how every number was only an even number in 10,000 pages of model code. You should be allowed to say that. It's in the evidence.
That's exactly something that would need rebuttal evidence, that would need testimony.
Do you think the AHO's office is not allowed to do that?
I think that's the purpose, that the AHO might have additional questions for some of the experts. I can do this as an example, I mean, pretty easily to see why I think it's inappropriate. If Ms. Mullins could just share CalAm Exhibit 155.
Sure, go ahead, please, Ms. Mullins. This will probably take a moment. And while she's pulling that up, I'll just foreshadow that what I think is likely what I'm going to do here is defer this question. One of the reasons is if I were to admit or consider admitting model files into evidence, I think what we would need to do is then sort through the model files and figure out which ones are actually relevant to this proceeding, because it's my understanding that some of the early model files are no longer even relevant. They were initially submitted and then now have been superseded, if you will. And that's what, I mean, I think
We
would
think
have-
they're all, we think they're all relevant. I'm sorry.
So you think they're all, including those that were filed, I don't know if it's phase one, early in this proceeding?
Yes. It's not a relevance issue. Okay. It's a weight issue. But I don't think they're all need to clog up your evidentiary record if nobody does anything with them. That was my
I see.
suggestion a long time ago. But that isn't a relevance concern. Mr. Burchard, while they're looking, could you tell me what 155 is?
It's model files from CalAM's related SWB sensitivity run control files. And the point being, just if you open up that file, it's a zip file, as most of these things are, you then get 3 other files that you probably aren't going to be able to, most people will not be able to open because we don't even have the programs necessary. That's not something that is appropriately citable.
On the other hand, that's an example which isn't exhaustive.
All right, I think here we
These
are,
are model
Mr. Burchard.
files. Yeah, this is my point. These are model files. This is not something that you can cite. How would you cite this?
I think this really boils down to, and what Mr. Osias just pointed out, and he said, it was a really short rebuttal period. We didn't actually catch everything, is allowing folks to dig into these model files and raise new issues or new critiques. And the only reason they'd have to do it this way through the model files is because they don't have anything in their actual testimony to cite on this because it wasn't raised. I think to allow folks to go back and raise a whole bunch of new issues at this phase of the proceeding is highly problematic and just invites a need for another round of testimony.
Okay, so let me just say one more thing about that. In my experience, which frankly is too many years for me to count now, sometimes cumulative evidence is helpful. So exhibit X, Y, Z, and page 1988 of model file Q all supports the previously offered opinion of X. Okay? Is that last citation inadmissible? It shouldn't be. Doesn't have to be a new issue. I totally disagree.
So here is what I think I'd like to do here. I think we should not admit these model files into evidence today. It also sounds like no one is arguing that all of the model files should be admitted into evidence today or ever, because Mr. Osias, I understood your caveat, which I think is helpful, is that if any are admitted into evidence, it would be those that are actually cited to and are being pointed to for some reason. I think the way we should handle this, or the way I'd like to handle it, is to ask the parties if you are going to cite directly to a model file, however you would do that. I mean, that's a question of, I'm not even sure how. Anyway, you can get into the technicalities of that. There must be a way to do it. Whether it's a screenshot, I don't know how that's done, but we can deal with that if we get to it. If you are going to cite directly to a model file, just something that's not identified as an exhibit in the evidentiary record, that you file with it a motion. I don't know what would be I don't know a motion, but a motion to admit that portion of the model file into the evidentiary record, I almost, be sort of analogous to like a motion for official notice of something like that. And that would set us up so that the other parties can respond. And then I can consider in that particular example whether or not it's appropriate. Because we're speaking in hypotheticals and these are really complicated. And I have a feeling, I think you're making I think everyone is making this point, Mr. Osias and Ms. Meisenheimer and everyone, Mr. Burchard, that in the actual application, it may be more clear whether or not this is a legitimate citation to what's in the model file that anyone can see, that's obvious that anyone can see, or whether this is new expert opinion that is now being introduced in an untimely manner. And I have a feeling when it's laid out with some clarity, it'll be easier for me to rule rather than ruling on a hypothetical situation, which we're all trying to come up with examples. So that's what I'm trying to do is put this so we're in a concrete situation. So that there would be a motion to bring that portion of the model file into the evidentiary record, to explicitly recognize that as part of the evidentiary record, that you would file that with your closing brief or draft report of referee, wherever the reference is made. I assume it would be in both if you're making that kind of a reference. And then other parties would have an opportunity to respond. And then I can make an appropriate ruling on that. That is my proposal. Before I finalize that proposal into a direction, I will turn to all of you. I'll turn to you first, Mr. Osias, and then the other parties. Do you have concerns about that approach? I mean, are there any
No.
comments on
No,
that?
no. The workload is you do it, you try to live within what recognizes that it's not you're not at liberty to try to bring in new opinion or new evidence. So you try to live within that. You get a bunch of arguments, et cetera. But no, I think that's fine. I also don't want to hear from everybody that, geez, you made a big fuss and then you didn't cite anything.
Well,
I'm trying to be prophylactic about anticipatory objections.
Well, and I am trying to set you up for success, Mr. Osias, because I think I take your word for it that you're being genuine and you aren't at this point foreshadowing anything in particular, and we're all trying to work in this hypothetical universe.
Right. So I think I totally agree that rather than Mr. Burchard and I trying to be creative as we sit here and pull different exhibits off the shelf in 20 seconds to show you contrary examples of a model file, we ought to see if anyone cites to any page or however you label a piece of a model file, and why, and for what. And then we can have this argument again. And something needs to tee it up. So to the extent it's an offer into evidence or a motion to consider it as evidence, however you want us to label it, I'm okay with that procedure.
Thank you. Ms. Meisenheimer, do you have any comments on this?
No, I'm fine with that approach. What timing? This is all sort of evolving in process. What timing would you be thinking of for those motions related to model files?
Well, those would come in. Well, I'm envisioning those would come in with the closing briefs. So on November 13th by midnight. Then I think your follow-up question rightly would be, what time do I want a response to those motions? Which I'm open to suggestions. I guess my initial thought would be something like 10 days. November, I hope that may put us on Thanksgiving, but let me see. Let me pull up a calendar.
No one should have to work that weekend, please.
Right. I think that is exactly Thanksgiving. So would you prefer, Ms. Meisenheimer, do you have an opinion about whether we make that the 22nd or we make it after Thanksgiving? I'm not sure which is worse.
Pick your poison, right? I think November 27th is probably better, given that everyone's travel plans shift around. Yep. Some people leave early, some leave late.
So I'll be looking at November 27th for responses. Thank you. Mr. Burchard, did you have any comments on what we've discussed?
No. Thank you.
Thank you. All right, then we'll go with this approach. And Mr. Osais, with it, or any of the parties, because this is open to everyone. Whether you style, I don't have an opinion, whether you style it, as you said, either as a motion or as an offer into evidence, whatever you think is appropriate, that's fine with me. We know we've had, I also hope that this robust discussion, which I appreciate, is now in the record. We can show we thought about this, we thought about it hard, to the extent this, hopefully not, but to the extent this comes up again for you in court, you at least have this record to show what it was we were thinking, that this was a very conscious effort to get the right evidence into the evidentiary record. So we all have that.
Thank you.
Thank you. We've been going at this for over an hour. I think this may be a natural break for 10 minutes so we can prepare our minds, but what I would propose we move to next is CalAm's slides. I have written down slides 43 and 44 of CalAm 192. I think if I remember right, Mr. Brochard, you raised the objection to these slides as not this is Mr. Durbin's, they're Mr. Durbin's slides, as I recall, and that your objection was that they were not within the scope of his direct or rebuttal testimony, and then also did not respond to any rebuttal testimony from CalAm, I mean, from the other parties, and therefore that they should not be admitted into evidence. And I just wanted to check with you that those, I appropriately paraphrased your objection and that your objection still stands to slides 43 and 44.
Yes, I believe you did.
Okay. So I'd like to take just a 10-minute break, and then we will pick up with consideration of the slides. Mr. Osais, I will foreshadow to you with that I will have questions about, I had thought about, I was working through all these issues, and I thought I should go and look at Dr. Kincaid's rebuttal testimony and figure out whether or not these slides actually respond to any of the rebuttal testimony. And then I decided that you would tell me what testimony these slides were intended to respond to. So that will be probably my first question once we come back from our 10-minute break. Just
I'll have to admit to you, that seems so long ago. I'll now have to refresh my recollection. What time did you want us back?
In 10 minutes, we'll break until 10:34, please.
Okay, can I add 5 minutes on that for a biological visit, so then I can go back
And
and
then
look
you
at
can
the
also
exhibit?
have a thought. Let's do
Yeah,
10. Well, let's just go with 10:40 since
Thank you very much.
we'll return at 10:40. Thank you. See you all soon. All right, welcome back after our break. I did want to, after the break, I just had one brief follow-up on our discussion about the model files. I had the benefit of talking with my team because this is something I wanted to articulate, but I wanted to make sure I got it right before I said it, which is that just to clarify for all of your understanding, AHO staff or water board staff, we have not, and we are not intending to manipulate these models or the model files in any way. So it's not, the AHO is not going to be creating new model runs of any kind. And I just wanted to clarify that we may, as I understand the correct description is, we may, and staff has run the model, but these would be model runs that were already done. But just to verify that the output is the same as the output that was already provided to us, and to see how the calculations work their way through the model. But it's not the case that we're going out and, manipulating the model, creating a new model runs, any of those things. That is not happening. So I just wanted to clarify that for all of our understanding and for the record, and just put that out there. And I wanted to make sure I got the words right. That was my understanding, but I wanted to make sure I got the words right and verified with my team. I think where we left off is with slides 43 and 44 of CalAm 192. So I probably it makes sense for us to go ahead and bring that up. So Ms. Mullen, if you would please, Mr. Wilkins, you have your hand raised.
Just
Please,
a quick question before you change. Mr. Lilly at one point said that after the models are submitted, that your staff may want the experts to do additional work. And I just, for our experts in terms of timing and letting them know, it sounds like if you want testimony or you may have questions, but you're not going to ask them to do additional work at this point, or do you know the answer to that?
So let me give you a qualified answer to that. It's not the case that we're going to ask your experts to go, do additional, change the model, something like that. I have talked with my team. There was some question about whether there's certain, hopefully I can get this right, but output or compilations of data that may have already been done that just wasn't submitted. And we may ask for that as we go through. I'm trying to think of an example. I think the idea was that it was information that would have come out of a model run that just may not have been submitted to the AHO, and that you likely would already have. And if we think it's relevant, we may ask for that, but I'm not sure that that's the case, or would even, I'm not sure that that's the case, but I don't anticipate there would be additional work in the sense of, change your model in this way, or work, that kind of extensive work. Is that a fair response to your question?
Yeah, I mean, it doesn't sound like there may be some minor things, but we don't need our experts to be on standby to potentially run a new scenario or do something like that, is what
Right.
I'm saying.
That is my understanding. And also you can tell your experts to go, I mean, maybe they need to prepare before mid-January, a small amount, but to go on vacation and take a break. That's probably not your job, but it's important for everyone to take a break once in a while. All right, moving back to CalAm 192, Ms. Mullen, I think it would make sense to bring up CalAm 192, and we can go ahead and go to slide 43, which I believe is on page 43. We can start with page 43. All right, and I think if we blow that up at the bottom, we will see at the bottom. I can't see very well because I went outside and now I can't see it all, but I believe it says page 43 at the bottom right-hand corner there, or slide 43.
It does.
And then, thank you, Mr. Osias. You can see and I can't. Don't worry, my vision will kick in a moment because we're about to talk about these slides.
No, you're about to be right on page 44, I think.
I think since I briefly summarized Mr. Brochard's objections to this slide, and I had asked you, Mr. Osias, or foreshadowed that I was going to ask you, to what rebuttal testimony this slide responds. And so I will give you the floor, Mr. Osias, if you have thought about and have something to say about that.
I do, but I want to make sure I'm responsive. So is the sole objection that this slide is not in any way responsive to rebuttal testimony of MCWD or Marina?
And Mr. Burchard, I will turn to you.
The objection was that the summary slides are supposed to be a summary of the expert's testimony, either their direct or rebuttal, and this is not. Mr. Durbin did not testify about these croppings in this phase. And then I think, as everyone had pointed out, the experts would occasionally make additional slides for their presentations if it was responsive to something that was raised in rebuttal. And this, again, I don't believe this responds to anything that Dr. Kincaid said in his rebuttals, especially as to anything that Mr. Durbin had testified to.
Okay, so did you want my response now, Ms. Kinsey?
Yes, please.
So let me start with, this is intended to be within the extra slides allowed in response to rebuttal. So that'd be point one. And I think I already gave you the site for that when we were together last time.
Yes, thank you.
Second, I reject, although obviously it's not up to me, but I disagree with the assumption that Mr. Durbin is limited to responding to rebuttal of Mr. Kincaid. I had only a few minutes. That's not, it sounds like whining, so I apologize for that. I didn't mean it as a whine, but I'm just saying I don't have an exhaustive example. But I can tell you that Ms. Nelson and Mr. Trudell also, well, I know Ms. Nelson did. I didn't have a chance to go to check Dr. Trudell, but as an example, to the first one I found, Ms. Nelson's rebuttal testimony on page 5, which is MCWD 168, she says on line 21, yes, Dr. Ye, Mr. Leffler, and Mr. Durbin, collectively referred to as CalAm experts, ignore or do not acknowledge the materiality of project impacts in their testimonies, ... And so I'm use that as an example, not exhaustive, of course, that there was rebuttal of others than Dr. Kincaid that the CalAm experts are entitled to respond to. So now going specifically, let's start, if we can, with Exhibit 44. I know that's cron reverse or pagination reverse, but that one's somewhat easier, I think, to just try to grasp.
You mean slide 44?
Yeah, the next page. I'm sorry. What did I say? Exhibit?
You said exhibit.
Yeah, no. All right. I meant page. So I apologize, Ms. Mueller. There you go. And you'll note it doesn't have a page number, which is what you were sort of suggesting before. And I don't know why, but I apologize for that. So this is slide 44. Okay. And in one sense, it's a compilation of evidence that's already there that sort of lays a foundation for his rebuttal testimony. There's no dispute about where the outcrop is. We've got in evidence earlier testimony and official reports about the hydrogeological mapping. There's no dispute about where CEMEX is. There's no dispute about the boundary for MCWD or these distances in terms of the previous model, et cetera. So this slide actually contains no new evidence other than to putting it all on one page. And so to the extent it's the objection is you can't introduce new evidence in response to rebuttal, except for the limited exception that you can. It's not even new evidence. More relevant is the slide before, so let me turn to that one, okay? That would be slide 43. And first I'll describe what's in this a minute, and then I'll answer your specific question, Ms. Kinsey. What does it respond to? But what you see at the bottom is that it's a modified portion from Cal-Am 158 figure 1. So certainly everything on 158 figure 1 is not objectionable because it's already in. The blue boxes are not there. The highlighting is not there. The boundaries of the MCWD model are in other testimony already in evidence. So we have, let's just look at a couple other, I guess, Dr. Kincaid's testimony now. So is this sufficiently in everyone's vision so I can turn to other slides and say how it relates?
Yes,
Well,
thank you, Mr. Osias. And Mr. Burchard, did you have a comment?
Yeah, I think the question was simply, I mean, I think at this point we've agreed it's not in Mr. Durbin. This is not a summary of any of the written testimony that Mr. Durbin has provided. So then I believe Mr. Osias's argument is, well, it's a new slide we can create to respond to their rebuttal. Okay. Dr. Kincaid's rebuttal is MCWD 169. Ms. Nelson's is MCWD 168. What is the page and line number that this is responding to? That's the only thing that should be at issue right now.
Yeah, and although, again, without having sufficient time, it's not just Dr. Kincaid, it's every expert who correctly wrapped the three experts together. They used to be called the HWG. Now I guess they're relabeled the Cal-Am experts, and it can respond to any of their rebuttal. But I'll go back to Dr. Kincaid's, and Mr. Burchard was correct. I'd like to bring up 169.002. But again, just to highlight, I don't want to lose this. We're looking at, in this slide, the 180-foot aquifer, where it is, and it goes offshore. The DSA, where it is, and where it goes offshore. The 400-foot aquifer, where it is, and how it goes offshore. And how MCWD modeled that with the vertical black bars, okay? So now if we go to MCWD 169, page 22, I believe, that should be Dr. Kincaid's rebuttal. Perhaps the full page is going to be the easiest to use. There we go. So in the lower legend, in not the bolded line, you'll see where it says MCWD-WBSSM. This is an illustration of the MCWD model. It's graphically showing groundwater elevation. You'll see how it's modeled offshore, which Mr. Durbin disagrees with, as he explained in that slide. You go to the next slide, no, next page, sorry, 23. Oh, go back to 23, sorry. This is the Cal-Am model. You'll see the offshore. They're different between 22, 23, and he's explaining why they're wrong. to have theirs modeled like they do. This is in the rebuttal. And then if we can go to the next page. And here, if you'll give me, in the interest of time, a quick reminder that there was a lot of testimony by Mr. Durbin in direct and in rebuttal, and a lot of testimony by Dr. Kincaid in rebuttal. And both of them had spent a lot of time at the hearing in summary about profiles. Okay. And this is from Dr. Kincaid's profiles. And perhaps the next one is just a little bit easier to see. So let's go to page 25. Thank you. And this is just for orientation, the upper 180-foot aquifer. And Mr. Durbin was very clear that he thinks they modeled it wrong and that their profiles are wrong. And in part, they're wrong because of where they start and how they calculate the gradient. And when I say where they start, at the shore and the elevation. And he's explaining the fundamental mistake they make in their simulated model. And you'll note at the top, this is simulated gradients, supposed to be model gradients. This one is from the MCWD model. And Dr. Kincaid is showing what Mr. Durbin showed and what he thinks is correct. And Mr. Durbin is showing the reason why Dr. Kincaid is wrong. Okay, now he had a summary slide, but he also had a lot of discussion about it. So I'm not going to try to paraphrase his testimony, but that's what it relates to, Ms. Kinsey. And obviously there's lots and lots of pages on profiles that are influenced by some of the same reasons. Okay. It's not the only reason the profiles are wrong. It's one of the reasons the profiles are wrong.
Can I respond quickly?
Certainly, Mr. Burchard, go ahead.
Can we go to page 22? You'll see the gradient profiles. They go from a point inland to the shoreline. And then can we go to 23? Again, they stop at the shoreline. So no, Mr. Osias is incorrect that the slides from Mr. Durbin is trying to put in don't have anything to do with the gradient profiles and the offshore outcropping. The gradient profiles go from the shoreline, not some offshore aquifer outcropping. They go from the shoreline to some point inland. And although this shows more green going out into the ocean, the shoreline, I believe the simulated groundwater elevations are roughly the same. At least they look the same. They look to be the same color in both 22 and 23. So that's the slide. Mr. Durbin's slides that we're talking about are not responding to these gradient profiles. He has a whole bunch of other slides that deal with that. And if you go to 23 or 24, I'm sorry. Again, you'll see on the top left, it says coast, not middle of the ocean. So the profiles on the gradients are from the coast to some point inland. It has nothing to do with the outcropping.
And my reply is twofold, Ms. Kinsey. One is,
Go ahead.
it's why Dr. Kincaid's profiles are wrong. And second, just go back one page. I'm sorry. Yeah. This is a figure that is not just a profile map, right? This is simulated groundwater elevations under the CalAm model. So all those colors are proper and fair to respond to. And you go back the next page. No, back, I'm sorry, I'm going reverse. Yeah. And where the MCWD model doesn't extend is proper rebuttal. This is an objection that either I guess that says, and I know Mr. Burchard is much too kind and we get along much too well, but he says we cheated. We're responding to something that wasn't brought up. It's brought up. We didn't have to agree with it. doesn't have to be the focus of everything that Mr. Durbin said. It's certainly fair game. And it underlies in part why there's this disagreement about what happens with gradients. It underlies in a large part why there's disagreement about the extent of seawater intrusion. And where it starts, I mean, this is more common sense, so pardon me for arguing, but if something starts far away, which is what the real world is, it could be relevant at least to how long it takes to get somewhere. And so all the CalAm experts have opined with different opinions about why the seawater intrusion modeling disagrees with each other, and the absence of the seawater floor layer and the failure to consider where the outcropping is and the stacking up of the model constant head in the location where it was shown on the objection slide 43 is the illustration of the disagreement that all the experts have with each other, and it's responsive to that.
All right. I think I'm prepared to rule on this one. Thank you, Mr. Asias and Mr. Brochard. I am going to rule to exclude slides 43 and 44, and here's why. I do think, you know, all of this is so complex. You've all been working together in different ways for so long, and the testimony, I understand the testimony is all interrelated. But I think here there was a burden on CalAm because these are slides that appear to be outside of the strict scope of Mr. Durbin's phase 3 testimony. And it's not obvious to me that it responds to specific rebuttal testimony presented by either MCWD's witnesses or Marina's witnesses. You know, all of this is within the same general subject matter. I understand, not just general subject matter. These issues keep arising, but I don't see the connection here between a specific point made on rebuttal and this specific point made by Mr. Durbin in his slides and his illustration. It may very well be that Mr. Durbin is responding to issues that were raised prior to rebuttal. It's just not, that connection hasn't been clear to me, and I think it's fair, given the circumstances, to hold a strict boundary there that that there needs to be a clear connection between these so-called extra slides and the rebuttal testimony of specific witnesses from the other parties. So I am going to exclude CalAm slides 43 and 44 from CalAm 192. Based on that ruling, Mr. Brochard, do you have any additional, are there any additional outstanding objections to CalAm's exhibits?
No, I do not believe so.
And I believe with that ruling, we have addressed, well, unless there are cross-examination exhibits, so I'll ask you this, Mr. Asias, are there, oh, I'm sorry, Mr. Wilkins, I did not see your hand previously. Mr. Wilkins, do you have something to say on this?
I can't recall specifically, but there was an issue relating to an exhibit. I thought it was an exhibit, or whether it should be an exhibit, that was the CPUC mitigation monitoring and reporting plan. I can't remember if that's an evidentiary exhibit argument that we were dealing with, but I know that issue was still live, I believe.
I believe that was resolved once again by identifying the PUC ordered MMRP, which is in evidence, and the modified MMRP submittal, modified in other areas, frankly, but nonetheless, and not yet acted on. Both those are in evidence, and there's not a disagreement about what either of them is. So, and we went through this again with Ms. Muzine being present. She wasn't the last time, but had sent me an email saying there was no objection. So I'm not sure what you're referring to, Mr. Wilkins.
I could be wrong. I can't remember how that, I was trying to remember if that was resolved or not. And if it is, then I apologize.
There's no need to apologize. I don't have a note about it either. I do recall now that he mentioned this conversation, and I think we resolved it by stepping through the specific exhibit numbers and verifying what the documents were. But Mr. Wilkins, if or any party after our hearing day today, if there are issues that come up and you think we just missed them, raise them with my office and we can figure out how to address them, because we have been through a lot.
On that one point, and I haven't checked today, and I raised this a couple weeks ago, or a month ago, the exhibit admission forms that, at least for Marina Coast, were not updated to show any of our exhibits have been admitted. And that could be now updated, but that would be helpful. I guess we could address that when we get to our exhibits too. So, but that's one of the issues. I'm not sure if all the exhibit ones have been updated for what's been admitted or not. And maybe if you know the answer to that, that would be helpful to know.
Thank you, Mr. Wilkins.
Before we
Ms.
go on
Meisenheimer.
to the broader question, I had looked at the transcript on the MMRP documents, and my recollection is 68 had been admitted and 131 had been admitted. I think the question was about 98. So Cal-Am had said, can we treat the questions we asked about 98 as being really about 131? And that's the last note that I have. Because I believe 98 is the one that had not been approved by the CPUC. But Ms. Muzine may be able to address that.
Real quickly, though, I want to remind everybody, and I hope my reminder is helpful, that Ms. Meisenheimer's description is correct, but we then walked through line by line the section that the questions were asked about to show that they were identical in connection with that treatment of one as if it were the other. So it wasn't just in lieu of it. It's because the sections asked about were in fact identical.
And again, my recollection is that there may have been other parts of Exhibit 98 that were not identical, and that may have been why it was not being admitted. But I would defer to others who are more involved in that discussion.
And Ms. Kinsey, this is Ms. Muzine from Marina Coast. I think that both Ms. Meisenheimer's and Mr. Osai's descriptions are correct, and where we landed was that as far as I understand it, 98 had not yet been admitted, and there would be no need to admit it because the questions that were asked about it with the consent of both sides after Mr. Osai's check over the lunch hour that day could be applied to an exhibit that had been admitted.
All right.
So if there's a pending objection to 98, it would be offered as a official submittal, but not acted upon, to show that there's no change to the section that we were talking about, and not for other sections.
And Ms. Kinsey, I think we would have the same trouble with that as we raised with Mr. Lilly, that it wouldn't be accurate to represent 98 as a Public Utilities Commission program where it is nothing that has been acted upon by the Public Utilities Commission.
Well, let's back up here to make sure I understand. Cal-Am 98 was something that was offered into evidence in a prior phase of this proceeding. Is that accurate so far?
Yes.
It was offered.
That was offered and not admitted.
And not admitted. So that's
And not denied.
right. So it's an
Correct.
outstanding offer that has not been acted upon. I see. All right, let me.
And I think, and Ms. Muzine will correct me. I appreciate she's been a pretty good scorekeeper here on this subject.
Yep.
It was objected to maybe for two reasons, because it was unclear whether it was the one attached to the decision or not. And if not, on what basis is it objected to? We have clarified it is not the one attached to the decision, and that one has been admitted. And we have established, I think, by stipulation or however you want to acknowledge it, that there's no difference in the section as 4.4 between the one that was attached to the PUC and the later dated one, which I believe Mazine was like a year later or something in terms of the date. And so it would not be offered as an official exhibit of the PUC action. It would be offered as the submittal to the PUC for action by CalAm for the purpose of establishing that we haven't asked for anything different. And when I say anything different, I mean on the section that relates to mitigating groundwater impacts with respect to MCWD.
And I think, and I'm sorry, I'm not following you. So you're offering it. So my understanding is CalAm is still offering CalAm 98 into evidence.
Yes.
For a limited.
For a limited purpose as an official document that was submitted. I mean, a question could be, well, that was in the PUC. Where does it stand? Did you change your mind? Or blah, blah, blah. And the answer is no. We offered in, let me put it this way. The MMRP was a required piece, as you're aware, of a CEQA process. As part of the order, we're required to submit a action plan to do stuff. So we submitted a new MMRP as our action plan. Has not been acted on, but it's been submitted. And for the relevant section, it's not different.
And
So-
then,
And so I'm not sure what the objection is
right, well, that was
when
going to be-
offered for that purpose. That's, I just,
Okay. Understood. And let's go ahead and I'd like to at least understand the objection. So I will turn to and Ms. Mullen, you could please go ahead and take down the slide. Then I can see the room better. I will turn to the room to please remind me of what the objection is to the admission. I know we had some of this discussion. I recall some of this discussion, but if a reminder as to the objection with respect to CalAm 98.
And Ms. Kinsey, what gave us discomfort in the first place, and I still hear Mr. Osias using the word official document or the implication that this is a document that the PUC has approved, and it is not. And we have established that. So if it is offered as CalAm's proposed mitigation, monitoring, compliance, and reporting program from, I believe it's July of 2019, I believe that would cure the objection, though we don't see the need for it as the relevant sections exist in the PUC approved mitigation, monitoring, and reporting program that was attached to the 2018 decision. So if the surplusage is not confusing, and if the 2019 document is clearly admitted as CalAm's proposed mitigation, monitoring, compliance, and reporting program, not as an official PUC approved document, then I think the objection is cured.
And maybe there could be some type of notation because it is on an official CPUC, if I recall correctly, 98 has their emblem on it, so it looks like it's official. Maybe something could be said in there, submitted or not official or something on it. So it's not,
Yeah.
so it is clear that's not an official CPUC document somehow.
it's not, Ms. Muzine's description is better than Mr. Wilkins. It's not been acted on. It has been accepted. It has been accepted into their records as a for action, which they haven't taken, submitted by CalAm, and it is. I have no issue with the description of it that Ms. Muzine said, and it's not purely surplusage, because following the decision, They were required to do it. And they did. And it didn't change. And the didn't change is sort of the relevant point I've been making this morning.
All right.
And,
Thank
and
you, all of
to-
you. Go ahead.
Just one last little word, and I apologize, but I want to be very clear. By the time this document 98 had been created and submitted in July of 2019, I believe the proceeding was closed. So it would not strictly, and I'm sure that it is not reflected on the proceeding docket per application 1204-019 at the PUC. So it would not be correct to say that it is on the record, so to speak. I'm sure the PUC would consider it a PUC document within their records, and should someone submit a Public Records Act request, it would certainly be produced, and it is available on a website related to the project. But it is not something that has been filed in a proceeding.
I think the thing, thank you. I think the thing to do here is that we will, it sounds like there's generally agreement and that the objection can be resolved. But there's concern, as what I hear is there's concern about flagging CalAm 98 as something different from CalAm 131. And then reflecting that CalAm 98 is not an approved, is not a document that has been approved or a plan that has been approved by the PUC. I think that can be addressed through a file. What I'd suggest is through a file name, and that the AHO would rename CalAm 98, maintain CalAm 98, but add a title to the document, which then would be reflected in any, for example, evidentiary exhibit list that's included in the evidentiary record and the administrative record that's submitted to the court, so that the file name reflects the fact that this is an unapproved PUC plan or document.
And that, you know, I don't, maybe the unapproved is okay, but I certainly don't want the implication that it's disapproved.
Right. That's why I would go with unapproved.
I'd say I prefer to say it's not been acted on.
I won't say, or
How about just pending?
I see, pending. Pending may be more accurate.
Ms. Kinsey, I believe Marina Coast would be comfortable with something along the lines of CalAm's proposed mitigation monitoring compliance and reporting program pending before the PUC.
We would be comfortable with that too. Once again, Ms. Nadine has a mastery of the title of this document.
Good. Thank you.
My legacy.
Thank you to both of you. So with that, I will admit CalAm 98 into the evidentiary record with the caveat that the AHO will title the exhibit in the administrative record and the evidentiary record with the title that Ms. Mazine just said, and we'll get it out of the transcript. I won't try to repeat it here on the fly, to reflect our discussion today, and so that it's memorialized. And so when we go back and look at this document, we will recall this discussion and the importance. And anyone else who looks at the record, the document, will hopefully be on notice as to what the document is. Is there anything else? And thank you, Mr. Wilkins. Apparently we did need to talk about this document, so I appreciate the tip on this. Is there anything else with respect to CalAm's exhibits? I guess, let me rephrase this. Mr. Osias, are there any other exhibits that CalAm would like to offer into evidence that, or has offered into evidence that I have not, or Mr. Lilly has not acted upon?
With the
We have more to do.
Yeah, with the important caveat of the introduction of, to the best of my recollection, everything we've offered has now been acted upon.
And are there additional, and just to confirm, I think this
And
were there any,
recognizing the model discussion we had.
yes, recognize the model discussion, and then did CalAm have any cross-examination exhibits that were not already or were not already offered into evidence or had been accepted into the evidentiary record that you're aware of?
I think we've offered everything, including those.
Okay, you will have a chance to double check because we're not done with our day, so.
Okay, I'll try to have someone help me do that. I got to take it. I apologize for drinking on screen, but I'm starting.
And I will say, I've checked with my team. We have not updated the index. We have that on our to-do list. So we will update our records of the exhibit list and whether or not certain, which exhibits have been accepted into the evidentiary record. That won't happen before the end of our day today, of course. If anything comes up in our update that you think is incorrect, once those have been updated, we'll send an email informing you that those have been updated. If there's anything that appears incorrect to you, of course, please alert us, me, and we will decide how to proceed, whether we need to reconvene to talk about it or whether we can manage it just in writing to do that. And I apologize that we don't have those updated today, but we will get those updated so that we all have a mutual understanding of what has or has not been admitted into the evidentiary record. With that, I think it's time to turn to the City of Marina's exhibits. Before I do that, is there anything else before we make that shift, is there anything else we should talk about with respect to CalAm's exhibits? Excuse me while I flip through my notes here. All right, so with that, we have an outstanding evidentiary objection from CalAm. I will call it the September 22nd objection, but this was an issue that was raised during phase 3 of the hearing, and then I asked CalAm to submit more information in writing about the objection. And this was an objection to the phase 3 rebuttal testimony of Mr. Tietze. I think it makes sense to go ahead and talk. We might as well just talk about that, and then I can formally ask for an offer of well, let's back up. I'm sorry. I will turn to you, Ms. Meisenheimer or Mr. Spalding. Would you please like to offer into the evidentiary record Marina, the City of Marina's phase 3 exhibits, and if you would please identify the exhibit numbers or the exhibit number range.
Sure. The City of Marina would like to offer into evidence, it's 58 through 66, 67 revised, and 68.
Thank you, Ms. Meisenheimer. And are any of those, if you would clarify for me now, are any of those exhibits used on cross-examination, or were those all submitted in the course of direct phase 3 exhibits or rebuttal phase 3 exhibits?
These are not cross-examination exhibits. They were all submitted in the normal course. The
Okay.
one other thing, we do have model files in our folder. And so I assume those will be, treated consistently with, I think they're not being admitted into evidence officially, but there's the ability to move to refer to them is where we're at.
Yes. Thank you. All right, with that, I'd like to turn to CalAm's pending evidentiary objection with respect to Mr. Tietze's rebuttal testimony. And then I will, once we deal with that, I can see if there are any other additional objections to the Marina's exhibits. I have read CalAm's September 22nd submittal. I read the City of Marina's response. I read those carefully. I don't want to, let me look to my notes here. We could spend, I'm sure, a lot of time on these. There are some specific issues that I do want to hear from you about, but I think the issues for the most part were very well briefed, and I have a good understanding of them. I will give a brief background. Here's what I'll do is I will give at least so let's start with the 2000. The first basis of objection from CalAm, as I understand it, to Mr. Tietz's testimony is reliance on the 2017 or 2018, depending on your point of view, AEM study, which has been admitted into the evidentiary record subject to the hearsay rule as Marina 22. And CalAm objects to Mr. Tietz's testimony because, to the extent that he relies on this study and the information in this study, CalAm discusses Mr. Lilly's, the circumstances of the admission of Marina 22 into the evidentiary record and its submission subject to the hearsay rule. And Mr. Lilly's, I guess we call it an admonition about how the study should be used. And as I understood the admonition, it was, I went back to the transcript, and as I understood the admonition, it was about the particular use of citations of the study by Dr. Ash, as I understood it. In Dr. Ash's testimony, he had essentially cut and paste portions of the study into his testimony, even though he had not significantly participated in the conduct of the study. And I understood Mr. Lilly's statements to be a direction to be with respect to that use, that this information from this, what was a hearsay document, was cut and paste into his testimony, and that didn't transform the information into something that wasn't hearsay, that this really is subject to the hearsay rule. And I think Mr. Lilly asked that any citations to Dr. Ash's testimony be from, with respect to the study, be from, to the extent possible, the published document, not this unpublished 2017, 2018 AEM study. My inclination here is to say, well, the Marina 22 has been admitted into evidence. Yes, it's hearsay, but experts can rely on hearsay if it's the type of information upon which an expert in the field would reasonably rely. But I wanted to give you a chance, Mr. Osias, or whomever may be speaking on behalf of CalAm. I shouldn't presume that you do all the things. This may be Mr. Betts, you're off mute. Mr. Betts, if you care to add to that, and then I will give a chance to respond. But I just wanted to let you know that this, to me, at least on a first look, looks like it pretty clearly is something that comes in because Marina 22 has already been admitted. So, Mr. Betts, to you.
Sure, thank you very much. So to set the table, we're trying to object, or we are objecting to Michael Tietz's reliance on these documents. And despite his reliable first name, his reliance on these documents, which we admit, that is Marina's 22 and 28, have already been admitted, suffer from the same defects. And as you read the record, so I very much appreciate that. But like Dr. Ash testified last time, he had no involvement in that report. It was done by other people. He reviewed it to see if it made sense. As you noted, he just cut and pasted based on what the attorneys did into his report, and Mr. Lilly expressed some concern. So the point, he said he found it disturbing and potentially not very accurate. And he was absolutely right. And what he urged people to do going forward was to be citing published technical papers. And that comment, like many others, was entirely ignored. And we have the same problem with Michael Tietz. He didn't write it. He didn't participate in the review of it. It's not peer reviewed. And from my recollection, he didn't even know some of these folks, or even if some of them were alive, from my recollection of Mr. Osias's cross-examination. So I do think you hit the nail on the head of, okay, what is hearsay? What's allowed? And in their opposition papers, and this is where I have my main concerns, is they cite the hearsay rule. If you look on page 2, lines 21, 22, and this is where I get concerned, is they cite to you what Government Code section 11513D says. And they say, open quote, hearsay may be used for the purpose of supplementing or explaining other evidence, close quote. That's the first thing that they do. The second thing they do to support this is on page 5, lines 12 and 13. They cite Government Code 11513C, and they say, open quote, relevant evidence shall be admitted, period, close quote. And my grave concern is that is not what the code section says. As you just noted, is what hearsay rule is under D, and I know that you know this, but it's hearsay may be used for the purpose of supplementing or explaining other evidence, but not over timely objection shall not be sufficient in itself to support a finding unless it would be admissible over objection in civil cases. So we'll get to the misrepresentation, but that's just not what they say the law isn't what it really is. Similarly, under 11513C, it doesn't say all relevant evidence must be admitted. And that's a very important threshold for everything that we're doing. It says all relevant evidence may be admitted if it is the sort of evidence on which responsible persons are accustomed to rely in the conduct of serious affairs. And it goes on. So our concern is it violates both of those, putting aside the misrepresentation. They are trying to use it in and of itself to support a finding, and they are. And secondly, we don't find in any circumstances that unpublished document, exactly as Mr. Lilly said, is the type of that responsible persons are accustomed to rely on the conduct of serious affairs. And obviously we believe that. Mr. Lilly seemed to have believed that, and I can't imagine anybody else relying upon unpublished articles that they had nothing to do with and don't know these people whatsoever. So overall, it did not meet the actual language of what the hearsay rules. I have a real problem of misrepresenting what the law says, and I think that's endemic of a lot of what we've seen throughout this procedure, of taking a piece of evidence and saying it says something else, a piece of a sentence, and you have it black and white here. They put quotes around it. They're making a representation to you of what the law says, and it's just not. So based on the misrepresentations and the fact that it doesn't comply with 11513 C or D, we do maintain that objection, and that's one of three.
So Mr. Betts, I just want to make sure I understand. Regardless of 11513, an expert may rely, even in civil court, an expert may rely upon hearsay evidence. Isn't that correct?
Well, no, under actually a whole new series of cases, including Sargon and the like, you can't just rely upon hearsay anymore. There has to be an independent foundation for the evidence that you rely upon. So yeah, there's a statute that talks about it, but absolutely not. I wish Sargon governed these proceedings. There would be nothing that the other side could probably get in, but no, there is no longer a blanket rule that experts can just rely upon hearsay. So for example, if the medical case, if someone wants to say, well, I just relied upon the doctor's records. No, the doctor's records need to be come in and authenticated before the expert can rely upon that hearsay. So respectful correction, I do not believe that's the law anymore.
Okay.
And having said that, again, I love Sargon, and this we'll get into when we talk about Dr. Kincaid's testimony, but under the alternative standard, 11513, which I think controls this thing, it talks about the responsible persons under the conduct would rely upon in serious affairs. And we know that that's just unpublished, unnamed articles that they had nothing to do with whatsoever is not the type of stuff we should be relying upon. We took direction from Mr. Lilly, and I think he was absolutely correct about this.
Thank you, Mr. Betts. And then with that, I will turn to you. It looks like Mr. Spalding, if you would like to respond.
Thank you. Thank you. I have 2 quick points to make. Number one, AEM is a well-accepted geophysical technique for evaluating groundwater. Dr. Rosemary Knight's AEM studies of groundwater occurred in this precise area that we've been dealing with in this proceeding, and they provide valuable data here. So Mike Tietze appropriately relied on these studies, and I think that's important because Mr. Betts is implying that they are not accepted techniques. He's also implying that even though Marina 22 has been accepted into evidence, it shouldn't be deemed to be reliable. I think both of those arguments are really off point. My second point is that this motion is based on a series of really faulty assumptions. Mr. Tietze clearly did not rely on Ted Ash's testimony. He didn't know he was alive, contrary to what Mr. Betts said, but he had no idea that he had been a witness in this proceeding. He didn't review his testimony. He didn't review the report. All of this was brought out on cross-examination. Number two, the 2018 AEM study has been accepted into evidence, as has the later published peer-reviewed study been accepted into evidence, and it's one of MCWD's exhibits. It's incorrect that the AHO presiding officer stated that the AEM study is unreliable. Clearly, as you explained, Ms. Quincy, Mr. Lilly had some concerns about the reliability of certain parts of Mr. Ash's testimony, but he clearly drew a line and said, when it comes to the report, I am accepting that into evidence, and he said nothing about it being unreliable. And finally, I'd say that clearly under California law, as most recently articulated in the Viamat-Tahoe case, which is a 2020 case, experts can rely on expert testimony, on hearsay testimony, if it is of the type that would reasonably be relied on by experts. And I think that Mr. Tietze himself in cross-examination made it clear why this is the kind of evidence that not only he, but also the other experts in this proceeding should be relying on. It's an important set of data. So we strongly believe that this motion needs to be overruled.
And may I briefly respond on 2 points?
You may briefly respond, Mr. Betts.
Sure. So we're not challenging Exhibit 22 and 28. We're challenging Mr. Michael Tietze's reliance upon it. And our comments about Mr. Tietze didn't remember anything about the people that wrote the article. Not that he had any recollection of Dr. Ash. That's not our issue. It's he had nothing to do with the article, nothing to do with these people. Didn't know who they existed, and we totally dispute that the AEM has any relevance. That it's junk science, as they put in there. There's been no one to come in to validate what's stated in that article. If they felt that Dr. Gottschall, and I'm sorry, no disrespect to the name of the authors of the article, bring them in if they're the experts to do it, but not someone that didn't have anything to do with those articles whatsoever.
Thank you, Mr. Betts, and thank you, Mr. Spalding. I think I am going to go ahead and rule on this portion of Cal-Am's objection. I do overrule Cal-Am's objection to Mr. Tietze's testimony on the basis of that, to the extent and on the basis that he relied on the AEM study, that's Marina 22. I do conclude that there's sufficient evidence in the record that the AEM data and study is the type of information that an expert might reasonably rely upon. Now, that said, I do recognize that there are significant disputes over the validity of the AEM study and the data that's included in this, I think the published article, as well as the unpublished version in Marina 22. And all of that, I think in this case, appropriately goes to the weight of the evidence and the weight to be afforded those exhibits, and then the weight to be afforded correspondingly to Mr. Tietze's testimony, to the extent it relies on the information in those exhibits. But I do overrule the objection in large part because Marina 22 is accepted into the evidentiary record. And Mr. Tietze did testify, as pointed out by Mr. Spalding, even on cross-examination, that in his opinion, this was the type of information that an expert might reasonably rely upon. And it was his judgment that it was appropriate to do so. So that portion of Cal-Am's objection is overruled. I think at this time, I'd like to turn to the second portion of Cal-Am's objection. I understand there's three. I've broken it down mentally into 3 parts, although I think part 2 actually has some subparts. I do have questions about this. I think it would be helpful for us to go ahead, Ms. Mullen, if you would please bring up Marina 62, which I believe is Mr. Must be Mr. Tietze's testimony, is Marina 62. Because there were specific objections from Cal-Am on page 7 that I would like to take a look at. So if we can go, actually, let's first go to page 6. Please. And then If we can scroll down, I believe the first reference here. Yes, if we can stop right there, Ms. Mullen, I appreciate it. So what I was trying to do is sort out, there were some quotations that Cal-Am objected to that were included in Mr. Tietz's testimony on page 7 and page 8. And I was trying to figure out what the quotations were from. So I looked at the exhibit list and I scrolled up here, and it looks to me here that if we look on line 17, there's a reference to Montgomery and Associates 2023A. And then the testimony states that the documentation report for this model, which I understand is the model developed by Montgomery and Associates, the swim model, is marked as Exhibit Marina 64. And my understanding is that Marina 64 is Montgomery and Associates 2023A. And I have a part 2 to this. You can correct me if I'm wrong in a moment. But if we could please, Ms. Mullen, go ahead and go to the next page, page 7. And here we have this quotation to which Cal-Am objects starting on line 5 through line 13, which is described as an excerpt from the meeting minutes. And that reference is the GTAC, this GTAC meeting that is referenced here. And a reference in the quotation, I'm sorry, in the parenthetical, Montgomery and Associates 2023B. I couldn't find Montgomery and Associates 2023B as a separate exhibit. I don't think it is. I don't know what it is. And I was wondering, Mr. Spalding, I think it makes sense if you would, if you can,
Right.
Offer some clarity on what Montgomery and Associates 2023B is. What document is that? Do we have it in the record? Has it been offered? Or is it a reference to something that's entirely outside of the administrative record for this proceeding?
Well, you are correct that Montgomery and Associates 2023A has been offered in the record. 2023B is not in the record as a separate document. And it is a copy of the meeting minutes. And we'd be happy to offer those in evidence if that would be helpful. Mr. Tietze just wanted to refer to a portion of those minutes, and these minutes are equally available to all of the parties. But he was talking about what he offered during those minutes, during that meeting that were captured in the minutes, and he used it to provide context and background for his opinion.
So Montgomery and Associates 2023B, I think you said, Mr. Spalding, that these were the meeting minutes from the GTAC meeting.
Yes, that's
But
my
what Montgomery is it a technical, were they attached to something in another Montgomery and Associates, to a Montgomery and Associates report? Is 2023 a report, or it's just the meeting minutes?
No, I don't believe so. I think that Montgomery and Associates, after the meeting, prepared a summary of the meeting. And that's why I think it's referred to in that manner.
Because it does raise, thank you. I mean, it does raise concern. I am concerned here that there's a direct quotation from a document that is not offered into evidence. I realize you're willing to offer it now, although the time has passed, I think, because we wouldn't have an opportunity to ask, the other parties don't, Cal-Am doesn't have an opportunity to ask questions of Mr. Tietze about that document. And then Mr. Tietze's quotation, where there's no way for us to verify whether the quotation is accurate. I mean, it's not something that, I understand it provides background, but it's not based on his own memory he was at the meeting. It sounds like it's not based on his own memory. It's a quotation from this document that we don't have. So it does raise some concern for me. I mean, you don't need to tell me, but I get the sense that maybe the document was omitted from the offer of evidence just in an error, which happens. That's, we were all moving quickly here. But I don't know if you have anything to add to those thoughts, Mr. Spalding, and Mr. Betts, I will give you a chance to chime in too.
No, we did not leave it out. We didn't see a problem with, or at least we don't believe that there is a problem with Mr. Titsa taking a quote from the minutes which were distributed to everyone at that meeting in order to demonstrate what his interest was in the purpose of the model and how it needed to be more specifically refined. And I don't think that legally it's required that every quote that's in testimony be supported by an independent document that is actually introduced into evidence. So we feel that this is a document that if anyone did have a problem with the document, it's readily available and they certainly could have cross-examined on it. But from my point of view, it's not a document that had to be introduced into evidence.
Thank you, Mr. Spalding. Mr. Betts, I will turn to you whether you have anything to add on this particular objection from CalAm. I realize part 2 of your objections included a few other references by Mr. Titsa, and you're welcome to comment on those as well.
Well, sure. Thank you, by the way, for the attention clearly you've put into all of this. So I appreciate that. So the first issue I'm not going to repeat, which is 2023B isn't in evidence in the first place, but there's a highlighted problem. You have hearsay, which isn't even in the record, on hearsay. So if you look at that first quote on line 5, it says the GTAC grappled with how to assess adequacy of the model, and it goes on. And if you look at the sentence on line 11, the GTAC generally agreed. So here you have hearsay on hearsay. You have a document referencing what some other people may or may not have said. You don't know who those people are, when they met. They certainly weren't under oath. What the contrary views are, what other statements may have been in 2023B or at that meeting. It is so beyond reliability and not in evidence. The foundational one is in evidence that we have grave problems with it. Not only for this one, and that goes to the other issues and other quotes that we have in here, is that reference to some meeting where we don't know who was there, what was said, not under oath, what the other statements were, allegedly captured in some document, which is also not in evidence, makes this all unreliable and therefore subject to be stricken.
Thank you, Mr. Betts. And then I think just to make this record complete, if we can please, Ms. Mullen, scroll down to actually the top of page 8. Let's pause there. Actually, if you go back, the quote here is it carries over. And I just want to verify, because there isn't a citation here. I assume, I just want to verify it, that this quote here that appears starting on line 26 with the simulated seaside subbasin seawater intrusion is unlikely to affect. And if you would scroll down, please, Ms. Mullen, to the next page. And you can see the completion of the quote, and there's no citation. Am I correct, to your knowledge, Mr. Spalding, that this is a quotation also from Montgomery and Associates 2023B?
That is my understanding.
Okay.
B, not A.
B, not A, yeah.
Right.
Based on this discussion, I am going to, yes, I'm
One-
sorry, I didn't,
just wanted-
please go ahead.
Thank you. One additional point I'd just like to make in hearing this discussion is, I mean, it does strike me that in essence, part of what Mr. Betts is saying is this is sort of a rule of completeness objection, right? You've got sort of a partial document pulled out here, and it's not fair to have the full thing, and the thing isn't admitted. And typically in court, when there's that type of an objection, the way it is remedied is by admitting the full document. So again, if there's that concern, I think that would be the typical path rather than exclusion, would be to admit the document to make it complete. And I understand that there are hearsay issues. I think we've talked about those, and Mr. Spalding can further address them.
Yeah, that's certainly not our only concern. I hope we've articulated that. And if they put in the full document, it may be subject to more examination. Our triple problem on top of that is it's referring to, again, people that we have no idea what they said, when they said it, why they said it, no cross, no under oath. I think that really makes it problematic, in addition to the fact we don't have the document.
And
Well,
I
that's
might just remind you,
You know,
Please go ahead,
Ms.
Mr. Osias.
Ms. Kinsey, that Mr. Titsa didn't show up until rebuttal, notwithstanding this model was submitted in June and then delayed to phase 3. There were previous motions about discovery related to Mr. Titsa that were denied. So we're now down to the consequence of a last minute witness allowed to go forward with no pre-hearing anything, who shows up for the first time on rebuttal, and then all the arguments that Mr. Betts made.
Thank
Want to
you.
remind you of that history.
I appreciate that. And Mr. Brochard, I saw you had a hand up. If you'd like to chime in.
Just briefly, my understanding was that, Mr. Titsa was offering these citations and these quotations to discuss the problems with the Monterey model, which was the foundation that Mr. Loeffler kind of made some adjustments to. Mr. Loeffler didn't have any personal knowledge of how the Monterey model was created at all. So the objections, any hearsay objections may also apply to that. But more to the point of, we don't know who said this at the GTAC. I think it's my understanding that Mr. Loeffler was also on the GTAC. So if anything was incorrect, or there was any additional information that needed to come out of those meetings, I believe he could have testified to that.
Well, now, I thought this was, Mr. Osias just reminded me, which I had in my mind, that Mr. Titsa's testimony was introduced on rebuttal. So
Yeah.
Mr. Loeffler, I mean, he could have testified to it, but not after Mr. Titsa raised the issue in his testimony here, right? I think all that, I shouldn't say all that aside, all that taken into consideration, I am prepared to rule on this, which is I am going to exclude the quotes objected to by Cal-Am. So that's page 7, lines 5 through 13. And then the quotation that continues at the very end of page 7 and continues on page 8 in Marina 62, that's Mr. Titsa's rebuttal testimony. And the reason for this, my conclusion, I don't think in all cases I would necessarily exclude quotations to something that's outside of the record. This just, to me, this raises the potential for a lot of confusion, because I don't have the full document. I understand that in court there may be an opportunity to admit the full document, but I think at this point in the proceeding, I don't want to do that. I think there might be fair arguments to allow additional investigation of that document and cross-examination on that document, and I just don't think it's worth our time here in this proceeding. So I'm excluding it on the basis that I think introduction of this quotation brings into question the entirety of this document, which is not in evidence, and allowing admission of that document into the evidentiary record would raise additional complexity that at this point in the proceeding isn't appropriate. So the burdens outweigh the benefits in this particular case. So with that ruling, I realize, Mr. Betts, that there are other elements of other objections to portions of Mr. Titsa's testimony. I could pull up because I have the full screen up, I don't actually have your Cal-Am's objections in front of me. But I think those other portions of the objections, I think the other portion of the objections were to references to the AEM study, Marina 20, or information in the AEM study, or references to the Marina GSP, which we're about to talk about. So I think those are, we can move on to the Marina GSP. Does that fit your understanding, Mr. Betts? Does that make sense?
Yes, thank you. That's the last part of it.
Great. So I would like to move on to this final objection by Cal-Am to Mr. Titsa's testimony based on his reliance on, I don't know the best phrase. We could just say it's Marina 66, which is, I will call it the purported City of Marina GSP, because as I understand, there is ongoing litigation as to the legal status of this document, of this plan. I'll call it a plan, by plan, I don't mean that it has been officially or has any particular legal status or official status. It's just a plan. that was prepared by the city of Marina. I guess I want to give the parties, both sides, an opportunity to comment on this. So I'll go ahead. I'll turn to you, Mr. Betts. I mean, I read the motion, obviously, but is there anything you'd like to add on this issue of the reported GSP and references to it?
Sure. And again, thank you for your detailed attention. So I want to address a comment that you made that's reflected in the opposition. I mean, it's undisputed. Marina is not the GSA. They have no recognized GSP. And the trial court, the very court that this is going back to, has made rulings already that they are not the GSA and that their GSP is not accepted. So the comment that there's ongoing litigation, there's not. It's been ruled on. There's judgments. It's final. There's an appeal, but that doesn't give life to litigation. And somebody has to, when there's an appeal, you have to overturn something. So it's not that there's ongoing questions about this. That's my only comment. That there has been a lot of litigation about this, tons of it, and an actual trial court ruling, the very court that gave rise to this proceeding here. So we think that puts an end to it, and trying to rely upon evidence that's already been rejected by a court is not the type that falls within 11513, C, D, any other letter, and or Sargon.
All right, thank you. And Mr. Spalding or Ms. Meisenheimer, I see you're both off mute. So Mr. Spalding, please, if you'd like to respond.
Thank you. Volume 1 of the GSP has already been accepted into evidence. It's MCWD 44. By adding in this volume, which is the comments by a number of people, both for and against parts of the GSP, is largely what volume 2 consists of. And it makes sense to have a complete GSP before the court. However, it's not legally invalid in any way. It's the DWR has the document, and as you saw in Exhibit 1 to our opposition, DWR has said that if the City of Marina prevails on appeal, it will immediately start processing the document. But leaving all of that aside, this document provided background and context for the testimony by Mr. Tietze, and it was very useful in his analysis. It explained why he knew quite a bit about all of these issues and why a variable density model could be very valuable. So it's totally appropriate for this document to be referred to, and certainly we oppose any effort to keep it out.
Thank you. Mr. Betts, do you have any final comments?
Sure. The admission of one exhibit doesn't make the second exhibit admissible. I think we had almost 2 hours of similar discussions this morning. We've had all sorts of testimony admitted, but we may not have model files admitted. We had all sorts of fights from the other side about the mitigation monitoring plan and whether the second one should come in. So simply because one exhibit comes in doesn't mean another exhibit comes in. And the fact that some parties said, well, if you hypothetically, speculatively prevail on something, we'll take a look at it, doesn't change the facts of the world, undisputed facts. This has been adjudicated. There's rulings on this. They lost. This forum should not be for time and time again trying to reverse prior rulings, whether it's this court, the PUC, the Coastal Commission, and the like. It just seems like this is once again, a pattern that we have here, that there may be someone out there that could take a look at this in the future if they win. So for those additional reasons, we think it should be excluded.
So maybe, Mr. Betts, my follow-up question is, I mean, I think you think let me phrase it this way. If City of Marina just prepared a plan, a groundwater sustainability plan, lowercase letters, right? And had it in their files, and put it on the shelf and didn't submit it to DWR and didn't claim that this was, prepared for the purposes of compliance with SGMA, would you have the same objection to its admission? I mean, what I'm getting at obviously is why does it matter? I mean, does it matter what its legal status is under SGMA in terms of whether or not it should be admitted in this proceeding?
And thank you. So my answer is yes, because I have all sorts of plans. CalAm has all sorts of plans that may be on the shelf. We don't put into evidence everybody's purported plans. It has zero legal significance. What makes this even more inadmissible is the fact that a court has already rejected said plan. So to answer your specific question, you bet. I absolutely would have objection to hypothetical plans, whether it's ours or someone else's, particularly one that the court has rejected.
Thank you. And I think I'd like to, oh, Mr. Wilkins, please go ahead.
I noticed we resolved this for CalAm's MMRP that had been submitted but not approved this morning by saying it's a proposed, and maybe we could agree to a name change for whatever it is. But it sounds like, and I don't know how it goes to whether Mr. Titsa could rely on it or not. So anyway, just CalAm suggested their document, which had not been approved, could come into the record with that caveat. Seems like that might be fair here too.
Yeah, I think it's very different. I mean, our plan, again, there's a mitigation plan that was accepted, was adopted, that we're required to apply, and there's an updated plan for it. So that's very, very different from what we have here. I mean, here it hasn't been accepted by anyone. In fact, it has been rejected. And I'm not suggesting we do this, but if it came in, it would have to be, rejected by court after extensive litigation. And the docket means nothing. I'm not saying we put a title on that, but it's very different than our mitigation plan that we suggested.
Well, the document has been accepted. Certainly volume 1 has, and the AHO found that it was relevant in order to do that.
Yeah.
So it seems quite inconsistent to take the position that volume 2 is not relevant and admissible and rather is unreliable. So we would be open to having it come in under a proposed label similar to what we did this morning. But we think it's certainly justified to come in on its own and be admitted. It's relevant and helpful.
Ms. Kinsey, just one other piece of background, if I might.
Sure.
And that's just to remind you, and I mean that sincerely, given how much you've had to absorb so quickly. But, we are talking about an expert relying on something, and what he's relying on is a plan, but you shouldn't assume that the city of Marina has any water rights, for example, because it does not. You shouldn't assume it's in the business of delivering water, because it does not. It's not your typical or common, I don't know if it's typical, but it's not your common city that's, for example, acquires water wholesale and delivers it retail. It's not in the water business. And so for them to write a plan for someone else to rely upon presumes an expertise that doesn't exist from their historic conduct, which is, again, not at all like CalAm, who had to put on evidence in front of the PUC of a mitigation and monitoring plan and has had to comply with CEQA regarding that, et cetera. So they're not parallels, and I don't think the pending is the solution. Thank you.
Ms. Kempsey, may I respond?
Mr. Spalding, please go ahead.
Yeah, that is not a very informed comment under Sigma. Sigma was enacted to transfer, in part, groundwater management from the state to local agencies. And any local agency that overlies a groundwater basin or has land use authority is empowered to become a GSA and to create GSPs. And literally hundreds of cities across California have done that. So to imply that the city of Marina is somehow not qualified or not authorized or is not able to create GSPs and manage basins is completely incorrect and a misreading of Sigma.
Thank you, Mr. Spalding. On this one, I am going to overrule CalAm's objection to Marina 66 and Mr. Tietz's reliance on the information Marina 66, but I have a couple of caveats that I want to be clear about. From my perspective, the status of this plan is either in limbo or it's, I guess I would describe it as in limbo in the sense of its legal status. Right now, it is not a controlling, as I understand, it is not a legally controlling GSP for for any area of any groundwater basin. But as a plan that has been prepared by the city of Marina, with respect to groundwater sustainability within that particular area and the information in that plan, I don't, because the bar is low here in an administrative proceeding, I think Mr. Tietze could rely on it. I don't think that's a basis to either exclude Marina 66 or Mr. Tietze's testimony that relies on Marina 66. But when I do review both the exhibit and the information in it, and then Mr. Tietze's testimony that relies on this GSP, or I should say, groundwater sustainability plan prepared by the city of Marina. First of all, I recognize that the city of Marina is a party to this proceeding. The document was prepared by the city. That's just that's just fact. That's where we are. I recognize that the legal status of the city as the GSA is at least has been rejected by the trial court and is on appeal. And the city of Marina's expertise or not in preparing this document will carry weight will be important in assessing the appropriate weight for the document and Mr. Tietze's testimony that relies on the document. So I think because of the low bar here, I'm not going to exclude it. I think there may be relevant information. There is sufficient indicia of authenticity in the sense that the city of Marina prepared it, and it's something that the city prepared with respect to managing groundwater within a certain area. But I think we would look closely if the AHO's draft report or the board's final report relies in any way upon this information, something we'd look carefully at in terms of how much weight to afford it, and the fact that those who prepared this document were not present during the proceeding to testify about how it was prepared or their thinking in preparing the document. So I have significant concerns about the extent to which it's appropriate to rely on the document, but I don't think we get to the bar of excluding the document from evidence entirely. So that is my ruling on that issue, which I haven't gone through. And then from that ruling, I think I have substantively addressed all of CalAm's objections raised in their September 26th objection. I'm sorry, not 26, September 22nd motion or objection. But I want to turn to you, Mr. Betts. Did I miss anything?
No, you've addressed what we've raised. Thank you very much.
I think next, then we want to turn to, and we may have to look at the time. 12:10, we probably want to take a break, but after the lunch break, we would then return. Oh, well, now I think what we should do is address the remainder of Marina's exhibits, because we are talking about the city of Marina. So I will turn to you again, Mr. Betts. Do you have any additional objections to the city of Marina's offer of exhibits 58 through 66, 67 revised, and Marina 68? That any additional objections that I've, in addition to those that I've addressed?
No.
Thank you. So with that, I will accept into evidence Marina exhibits 58 through 66, Marina 67 revised, and Marina 68.
And I apologize, having said you did strike a portion of 62.
Thank you. With the note that I struck portions of Marina 62, which is Mr. Tietz's testimony. And I will turn to Mr. Spalding and Ms. Meisenheimer. Are there any additional marina exhibits that are still in limbo that we need to address today in terms of moving them into the evidentiary record?
I don't believe so. Thank you.
Thank you. Now on that, I think it's an appropriate time for a break before we turn to Marina Coast Water District, a lunch break. But is there anything else we should talk about before we take a lunch break? All right, I'll give us just over 45 minutes. Let's return at 1 o'clock and we'll pick up where we left off. Thank you for your patience, everyone. And I think we will be kicking you off of Zoom, or you can log out politely and then we'll be logging into the same platform.